morning.
Hey, good morning. How are you?
We're here early, Judge.
Yeah, I got a little bit of an early start. Should be a busy day today.
Yes, I know. Yes. Thank you. Just. See. Does you have that?
No, I don't.
Okay. CSR.
Thank you.
I don't think this Terrence Jackson's supposed to be on 351.
Probably not.
Because on 11:30.
Because of that time, I don't
Yeah, that's
do exams
at 8:45. And then when I looked on the register of actions, it's from the same date. Probably same exam at the same time.
Pretty sure we did. Yes.
Yeah, okay, so. We can see what's happening. Yes.
Yes. It's ready for vacation. Christmas.
Found it. You want me to come to you? Sure. I can come, I just. Okay, I appreciate it. And, the judge. I guess you can take. Yeah, listen, no promise, no fees, okay, okay, all right, maybe she forgot, you know, she's been gone a whole month, so. There you go, all right, thank you. The, file for Jackson. Oh, Austin, I found the file, and so it is scheduled for December 8th. Okay. So you just cross that.
Homicide.
Oh, okay. I'm like, what's all right? Went home and told my husband, what your dad said about Sam. He just bust out laughing. He said, I guess people was paying attention to me more than what I thought. I said, yeah, they were. I said, he could stuck the fork in you. He was bust out laughing.
Morning. Good morning. Morning. Hey, good morning. How's it going?
Right, sir. Let me see, I don't know. Hold on.
The suspect may have thought it was the perfect escape.
And what you say the Zoom number was? Oh. Hold on, let me double check. Bring it home. Bring it home. Say no, what's your Zoom? Hang on. No, it's not fast. I understand. It's a number if you dial in. Not that I know of.
Ms. O'Meara, good morning.
Good morning.
You're here from our one and only probable cause conference today?
Really? You only have one?
Only
Wow.
one.
Wow, okay. Yep.
Ready on Jamie Harris.
Calling case number 230-60219, People versus Jamie Harris. The defendant is charged with count 1, felonious assault, count 2, domestic violence. Hands up for probable cause here. Clearances, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Catherine O'Meara, P53823, on behalf of Jamie Harris.
Ms. Harris, what's your name for the record?
What's on my mind?
Ms. Harris, tell us your name for the record. Unmute yourself, ma'am. Tell us your name.
Jamie Harris.
What's your pleasure, Ms. O'Meara?
I'm
Your
having
Honor,
a hard time. I'm sorry.
I've had an opportunity to talk to Ms. Harris about her case, and we'd like to set her case for a preliminary exam as soon as possible.
The court will continue to plead not guilty and set this matter for preliminary examination. How is December 6th at
December 6th was yesterday.
sorry, not December 6th, my apologies. December 13th at 10 o'clock.
That's a good date and time for me, Your Honor.
December 13th at 10 o'clock, file we continue.
Thank you, Your Honor.
Thank you.
I guess you're all set, Ms. Drain.
This was a real easy day.
Okay. We deserve to go on in. You're all set, Ms. Harris.
Thank you.
That'll be in person in 36th District Court.
In person. Okay, thank you.
Ms. Dane, what can I do for you?
Good morning, Your Honor. I'm here on Dawn Florney. It's a sort of a review date to determine whether the victim is deceased.
See if the victim is deceased. Okay.
Yeah. Did you have it on your docket this morning, Your Honor?
It is.
Okay.
I haven't seen Mr. Lamb yet.
Okay.
championship ring. Back in the day. One of those Michigan.
No, where, who was it from?
His son played for Michigan State.
Wow. Nice.
Beach Boy. 2020.
See it's on. Let's go on. Let's go on. What you say, see us? I found it. Oh.
Flex time. For
Right. Okay, Dave, count one, is transition. Say. So I think they was just not trying, not that it's dismissed, it's just not chunky. Yeah. So they update. Exactly, there's nothing wrong with it, so you're right. Okay.
Judge, I do have a Zoom hearing this morning with Judge Regina Thomas, so I'm going to log off for a few minutes.
Okay.
Thank you.
Let's see the two exactly.
Okay. Said 2 5s. You said 5. start. Yes. Oh, the exam is this week. This is just. Oh.
Was that the case with plans was, you know? Schedule that. December 20.
Oh, no, that's the exam day. It's all just, under impression, it's supposed to be here.
Well, that's what the last was. So that we scheduled.
Oh, okay.
Exactly.
But it's just. Okay. That was just his office, not. He's over at Third Circuit. She's gonna reach out to.
John, went to our 8:45.
I wasn't said that was fiction. You know, when they get a rain, they get the cost time state. And I said, not to tell them I didn't say it. They said 8:45.
Yeah, I just wondered.
You've already scheduled.
Okay, good.
Ms. Dane?
Yes, Judge.
So we're trying to get in contact with Mr. Lamb. I understand that he's in trial over the circuit court, so that's.
Oh. Okay. Judge, so this is a case, this case has obviously been on your docket a couple of times. The victim is deceased, and I'm thinking that people are unable to proceed.
Was this the matter that was scheduled out to December, late December?
It is, and it was up for exam on the 20th, and I think that your court reached out to me Monday to put it on a pretrial.
Right, because that's way too far out. And I'm not gonna be here on Tuesday.
Okay, what I could potentially do is present an order to the court for signature, and perhaps that'll take care of it.
Okay, sounds good.
Okay,
Thank you so
thanks, Judge.
much. All right.
Funny, I
Hey, good morning, how you doing?
So what? Now just think, I said, well, here, over here.
Oh, yeah, Ross said that. Right, I said that too.
Well, without some, she's, one of us will be back.
Where's that coming
Judge,
Yeah.
did you know a Cliff Witter that he was killed by a,
He's a good friend.
was he, I just was reading that police officer was mental.
Yeah. He was leaving the Super Bowl. I had just spoke with him Friday before, because he was out. He's coming back. He's like, I'll see you Monday.
That's- He had a lawsuit with his daughter went.
Yeah, they got $9 million settlement.
He's-
He was my go-to guy.
Yeah, I agree, yeah, good skills. He's only 58.
I didn't know he was that old. I was his first attorney. Many years ago. He used to work with that.
No.
What's going on? Yeah. I think that. James?
Yeah, you can.
I guess.
I know.
Yeah, for this, we just said that. Yeah.
I'm gonna go finish.
The next one for you, right?
I've got four, so we should be.
Did you have a fix?
Sadly, don't.
One, that's it.
Yeah, names on. Can I copy this? There's a big, so.
Okay.
judgments.
She's likely.
Oh.
Jeffrey. Yep.
Ready, Mr. Woodyard?
I am, Judge, yes.
Calling case 2358256, people of the state of Michigan versus Gary Jerome Johnson. Pending discharge to count 1 homicide, murder first degree premeditated. Count 2 assault with intent to murder. Count 3 assault with intent to murder. Count 4 weapons, firearms, possession by a felon. Count 5 felony firearm. Count 6 felony firearm. Count 7 and 8 felony firearm. Defendant has an official from the fourth offense notice. Appearances for the record.
Good morning, Your Honor. My name is James Kehoe. My P number is 82812 of the applicant.
And Judge, good morning to you and to your staff. Good morning, Michael Woodyard. My IP number is 64612. I'm a staff attorney with Neighborhood Defender Service of Detroit. We represent Mr. Johnson. Would you say good morning and say your name, please?
Good morning, Mr. Kehoe. My name is Gary Johnson.
All right, it is date and time set for preliminary examination. Are you ready to proceed? Yes, Judge. How many witnesses will be?
1, maybe 2, Judge.
You have any preliminary matters?
2 if I may, Your Honor.
Yes.
I believe there's going to be 2 stipulations this morning. For preliminary exam purposes, Your Honor, the people, the defendants have stipulated the identifications of the deceased, which is Diamond Mitchell, as well as there's a stipulation to Mr. Johnson had been previously convicted of a specified felony and was unable to carry a firearm back on July 22nd, 2023. Is that correct, Mr. Woodyard?
Judge, I'll stipulate to both of those facts on behalf of my client. Yes.
All right, the court receives those stipulations.
Then, Your Honor, the only other matter I have is I move for admission of proposed exhibit number 1, which is the medical examiner's report.
Any objection?
Judge, I have a copy. I've reviewed it. My client has a copy. He's reviewed it. I don't have a legal objection, no.
All right, and did it?
May I publish, Your Honor?
Yes.
Your Honor, may I just publish a portion of that to the record?
Yes.
This is coming from medical examiner case number 23-09101. Excuse me, this was performed by Dr. Omar Reyes, interim deputy chief medical examiner on Diamond Mitchell back on July 25th, 2023 at the Wayne County Medical Examiner's Office. It's my opinion that death was caused by a gunshot wound to the left chest. Postmortem examination revealed an entrance gunshot wound on the left lateral chest. There was no soot or gunpowder stippling noted on the skin surrounding this wound. The wound tract proceeded from this injury through the soft tissue of the chest, left lateral 9th intercostal space, liver, left lobe, inferior vena cava, pancreas, heart, right ventricle, right atrium, and superior vena cava, stomach, spleen, right lung, middle lobe, right lateral 3rd intercostal space, soft tissue, skin of the right breast. There were 200 milliliters of blood in the right chest cavity. There was an exit wound on the right breast. The wound tract was from right to left and upward when the body is viewed in the standard anatomical position. The bullet fragment was recovered from the liver and retained. manner of death is homicide, and that was signed by Dr. Reyes on September 22nd, 2023.
All right.
Your Honor, at this time, the people call Lakeisha Crowley to stand.
Judge, I do have a matter that I need to bring to the court's attention that is not now that the prosecutor's put all of his preliminary stuff.
Okay.
So the witness that people intend to call Lakeisha Crowley, obviously you don't have any familiarity with the record, so I'll just indicate she gave a couple of different formal statements to the police, one on July 22nd and one 6 days later, July 20th. The statements differ in a material respect. Once the first one on the 22nd, Ms. Crowley specifically did not identify Mr. Johnson as the alleged shooter in this case. It's important, Judge, for this fact. Obviously, when a person gives a statement to the police, there are criminal implications if they lie to the police. That's the first point. That's understood. The police reports from the scene in which officers spoke with Ms. Crowley, combined with the second statement from July 28th, where just spoiler alert, she identifies Mr. Johnson as the shooter. Those things combined suggest that on the 22nd, she was lying to the police when she said, I don't know who it was. Judge, I say all of that to say this. I believe that Ms. Crowley may be exposing herself to criminal liability once she testifies, and I would ask the court whether it will appoint an attorney to advise her on her rights against self-incrimination.
Mr. Kim?
So, Judge, there is a written statement. I guess to be consistent with Mr. Woodyard, I'll call it the first written statement, which was done. I want to make sure I have the right one. The same date at 10:30 in the morning, so we're all operating on the same page, Judge. So as you know, there's the question and answer written format by the officer, and the specific question is on page 3. The only question that is in the written format is, have you ever seen this person before? The answer is no. In terms of the written statement, it doesn't ask, do you know this person's name? Do you know this person's identity? Things like that. It does ask, would you recognize this person if you saw him again? The answer is yes. Is it an inconsistent statement? Potentially, Judge. Does that necessarily mean criminal liability? I don't see it, Judge. But I leave that to your discretion, Judge.
So in the following statement, the second statement that was given, do they attempt to clear that up? You said that you didn't know who this person was. How do you know who they are now?
It's cleared up, Judge, but there's also the 6-pack lineup that seems as well, Judge.
It's cleared up, huh?
They asked specifically to describe the person, identify the person, as well as then do the 6-pack lineup.
I'm talking about in terms of her not knowing who this person was. Inconsistent statement.
In terms of specifically asking that question, Judge, I don't believe that specific question was asked, as to the specific inconsistency. Unless I'm mistaken.
Judge, the police never did clear up the issue, as you put it, they did not. And I think, due respect to Mr. Kehoe, the first statement is more than simply Ms. Crowley saying, you know, I don't know who it was. She described physically the characteristics of the person she observed in a manner that is inconsistent with Mr. Johnson's physical characteristics, shorter, different hair, et cetera, et cetera. She described a different person, and she said, I didn't know who it was, which contradicts her statements at the scene, and which is contradicted by her later statement. I'm not saying all of this to litigate the issue now, but simply to point out that I believe she may be entitled to an attorney.
Let's see how it goes. How it goes.
Thank you, Judge. At this time, we call Lakeisha Crowley.
Good morning, ma'am. Please step forward. Raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I can't hear you. Thank you. Please have a seat in the witness box right next to me. Keep your voice up nice and loud and speak into that microphone that will be to your left. You may begin when you're ready. Speak into the microphone.
Judge, just one other matter I forgot to put on. I just moved for an order of sequestration with the exception of the officer in charge who just walked in, Judge.
Any objection?
I do not, Judge. I will note that Mr. Johnson has a couple family members in the courtroom. I don't believe any of them are raised just died witnesses.
All right, ladies and gentlemen, in the courtroom, if you are a witness or potential witness, I'm going to ask you to step into the hallway and to further focus. Also, people out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off of this. Mr. Kimberly Nickerson.
Thank you, Your Honor. Good morning. Could you just please state your name, please, ma'am?
Can't hear you.
Thank you. Ms. Crowley, I want to draw your attention back to the early morning hours of July 22nd, okay?
Yeah,
Where were you that morning, ma'am?
I know.
What street was your home at?
We saw 85, 86.
Okay. Silly question, is that in the city of Detroit?
Yeah.
Thank you, Judge. Now, who was with you that morning?
My best friend.
Who was your best friend?
Time.
Okay. Was that Diamond Mitchell?
Yes.
Was anybody else present with you that morning?
My mom, a couple of people outside early that morning.
Okay.
Because there was parties going on down the street.
Was this party still going on early in the morning, Ms. Crowley?
Yeah, there was people leaving, going home to their cars.
Okay, where were you when people started leaving?
Talking to my best friend.
Where were you guys standing at?
I was standing on the passenger side of the car.
What kind of car did, and your best friend, that's Miss Mitchell, right?
Yes.
What kind of car did Miss Mitchell have?
A silver SUV.
How long were you and Miss Mitchell in the silver SUV?
Not long because I woke her up.
You said you woke her up?
Yes.
How long had she been sleeping?
About 30, 40 minutes.
Okay. What were you doing before you went to wake up Miss Mitchell?
I was babysitting the twins.
Okay, well, at some point you woke up Miss Mitchell?
Yes.
Did she wake up?
Yes.
What happens after you woke up Miss Mitchell?
She was panicking, about to get ready to leave, about to put an address in her GPS. Car.
Where were you at this point?
Leaning against the car.
Were you inside or outside?
I'm leaning inside with the door open.
You said she was about to do all these things. What happens next?
She was texting, waiting on the address to come to her phone. Then a car pulled up and shoot my best friend.
So we're gonna take it step by step, okay? You need a moment, Ms. Crowley?
Oh.
What kind of vehicle did you see?
A silver car, a silver Fusion.
And had you seen this vehicle before?
No.
Were there any parts of this car that stood out to you?
The back bumper.
Why did the back bumper stand out to you?
Because it was damaged.
Were there any other distinguishing features about this vehicle?
No.
How many people were in the vehicle when it pulled up?
2.
Where did the gunshots come from?
The passenger seat.
Okay. Where was the fusion in relation to Ms. Mitchell's car?
The passenger seat was by her driver's seat.
About how far away, if you recall, was the silver fusion from your vehicle or Ms. Mitchell's vehicle?
Close enough to handle something.
How many you said that there was a shooting. How many gunshots did you hear?
I can't remember exactly how many, but it was more than 3.
I'm sorry, I didn't hear that.
More than 3, I believe so. I don't really remember how many, but I was just scared and I got down my door. When the gunshots was going off, I told my best friend to get down.
Miss Crowley, you said you weren't sure and then you kind of mumbled a little bit there, okay? We're just take a moment. So you heard several gunshots and then what did you do?
I got down on the ground.
When you say on the ground, would that be in the car or outside?
Outside the car.
Where was Miss Mitchell at this point?
Climbing over the seat and get down on the ground with me. And then she took off running in the house. And my mom shouldn't get her up.
So Miss Mitchell's gone in the house. Where are you at this point, Miss Crowley?
I was to get up on the ground, and by the time I get off the ground, that goes in house. My car go.
Where was Miss Mitchell?
And on my floor.
About how many people were at or near the car when this all happened? Miss Crowley?
Who was there?
Yes, ma'am.
Me. Well, my mom was right there, but she had to use the bathroom, so she was no longer right there. And my man was right there.
I'm sorry. You
My
said
man,
what's your man's name?
Charles.
Is anyone else present?
Me, like when people pull it off, everybody always run with gunshots go off, so no.
Okay. At some point, does anyone come to the location after the gunshots have been fired?
Yeah, the police.
About how long between 911 being called and police showing up?
I'll say, what, 15 minutes?
Do you recall how many officers initially showed up?
No.
Okay. Did you speak to those officers?
Yeah.
So I want to start. How many different officers did you speak to that day, if you recall?
At least 3 or 4.
I want to start with the first set of officers, okay? What did you talk to the police initially about when this happened?
I told them what happened. Well, with my friend, what happened to her getting shot.
What about what you saw?
Yes, I told them what I seen, that I was right there.
Do you remember who you described when you talked to the police? during the initial conversation?
Yeah, the conversation that me and my best friend had.
Okay, I don't want to talk about what you and Miss Mitchell talked about, okay?
But that's what I talked about the dog. So,
What about anyone in the vehicle that evening? You remember talking about that?
yeah,
Okay. How did you describe that individual that you saw in the vehicle?
I described him by her name.
What about any distinguishing marks?
Yeah,
What was that?
tattoos,
Okay, do you recall what kind of tattoos?
the cross
Where was the cross?
on the face.
What sort of name did you describe at that point? Did you know a legal name or a nickname?
The nickname.
What was the nickname?
Sosa. Sosa.
I'm sorry, are you saying Sosa?
Yeah.
Judge, I'm just going to renew the conversation we had earlier today. I think that the foundations that's been laid is clearly a question of liability.
You'll have an opportunity to question.
Thank you, Judge.
So at some point thereafter, Ms. Crowley, did you speak to any other officers about what had happened?
Yeah, I talked to a woman on the street.
Okay. Did you ever speak, or I should say, did you ever give a written statement during the, excuse me, that morning?
Yeah,
Okay. Do you recall who you talked to at that time?
oh. The gentleman here.
Detective Cooper, who's striker?
Yeah, I talked to him.
Okay. Did you talk about the individuals in the car at that time?
But you said earlier that day?
No, with Mr. Detective Cooper, excuse me. I want to talk about that conversation now, okay?
Yeah.
Okay.
Yeah, I just what you said myself.
You said you gave a description yourself, is that what you said? Is that a yes?
Yes.
Okay. What about at that moment, so we're talking just at that moment, did you give any names at that point?
Yes.
Are you sure?
Yeah.
Was that written down, Ms. Crowley?
Yeah.
If I showed you, well, so right now you're saying you're sure that the name was written down during that first conversation with Mr. Detective Cooper, is that right?
Yeah, I believe so, yeah, and
If I showed you your written statement from that morning, would you be able to find it?
yeah.
I guess I want to be clear. How many written statements did you give the morning of July 22nd?
I believe one or two.
So I'm going to show you that written statement, Ms. Crowley. I want you to look and if you find it, show me where that is, okay? I may approach. Ms. Crowley, your 3-page written statement, Ms. Crowley, can you just take a look at all 3 pages and look up at me, okay, when you're done? So it wasn't written down at that point, was it, Ms. Crowley?
No,
Just to be clear, this was your written statement, correct?
yes.
If you know, Ms. Crowley, was there a particular reason why the name wasn't written down at that point? If you know.
Because I was scared.
Why were you scared at that time?
Because of what happened to my friend. I don't know what might happen.
I just want to be clear, Ms. Crowley, had anybody said anything to you at that point? I don't want to know if anything was said, or excuse me, what was said, just if something was said. That makes sense.
No.
Okay. And just sticking with that same morning, Ms. Crowley, did you speak to any other police officers that?
No.
So I'm going to jump ahead a couple, or 6 days, okay, Ms. Crowley?
Okay.
Okay. Did you have to go and talk to the police again?
Yeah.
Where was that at that time?
No.
Okay. You recall who you spoke to at that time?
Okay.
Yeah, and that's the same Detective Cooper here at the table with me?
Yeah.
Okay. What did you and Detective Cooper talk about with regards to the people in the vehicle at that time?
Asking if I knew anything else about the case, but I was not sure. That's my best friend. I just wanted to basically get justice for my friend. But I'm just scared.
It's okay, Ms. Crowley. At some point, did you have to fill out another written statement at this point?
Yeah.
Okay. Apart from the statement, did you do anything else with Officer Cooper at that time?
No.
What about, were you shown anything?
I was shocked.
Okay, do you recall how many photos you were shown that morning, Ms. Crowley?
Like 4.
Prior to being shown those photos, did you guys have any conversations about that individual in the vehicle?
No, I had to just. Yeah, I know. No, I speak and I do.
So earlier, we're gonna get to the photos in just a moment, Ms. Crowley, okay? You had indicated that there was someone by the name of Sosa, is that correct?
Yeah.
How did you first come to learn of Sosa?
So they could, his brother.
What was the relationship between Sosa and Ms. Mitchell? If you know.
I found out at the end that they was in a relationship, but I didn't know.
So Ms. Crowley, do you know at that time if they were in a relationship still?
They wasn't.
Prior to July 22nd of this year, Ms. Crowley, what, if any, interactions did you have with Sosa?
No.
Did you ever spend time with Sosa and Ms. Mitchell together?
Years ago.
When you say years ago, about how many? 5 or more?
I would say at least like 2 or 3.
Then, Ms. Crowley, I want to talk about those photos you were shown, okay? How did that process go? What was the first thing you did?
Cry. Cry. I cried.
What did you see?
The person that shot me.
How did you indicate that to the police?
I don't know. Don't listen, my friend.
And when you filled out, or excuse me, when you went through these photos, did you have to do anything with them?
Tried to circle it.
Did you have to write your name or anything else in addition?
Feelings from it.
Would you recognize some copies of that photo in the form if I showed it to you?
Yeah.
And I've shown Mr. Woodyard what's been marked as people's proposed exhibits 2 and 3. May I approach? Approach the same. Ms. Crowley, I want to start with that top sheet, which is marked as proposed exhibit number 2. Can you just take a look at that for me, please? Do you recognize that form, Ms. Crowley?
Yeah.
I don't want you to read it, but what is that form, Ms. Crowley?
Identification. Signature. What I circled.
And Ms. Crowley, you said that was your signature on the sheet?
Yeah.
Is that a fair and accurate copy of that sheet as you saw it back on July 28th?
Yeah.
Apart from the exhibit sticker in the bottom right corner, have there been any changes or alterations to it?
No.
I want to move to number 3 really quick. The next sheet, Ms. Crowley. Ms. Crowley, what is proposed exhibit number 3?
It's a picture.
Ms. Crowley, is that one of the photos you were shown back on July 28th?
Yeah.
Okay. What did you have to do with that photo? Does that copy still have your signature on it?
Yes.
Is that a fair and accurate copy of the photo and your signature from July 28th?
Yes.
And again, Ms. Crowley, other than the exhibit sticker in the bottom right hand corner, have there been any changes or alterations to that exhibit?
No.
All right, this time I move for both the admission of proposed 2 and proposed 3.
Any objection?
No objection, Judge.
Admitted.
All right, may I retrieve and publish?
Amen.
So one thing I wanted to clear up, Ms. Crowley, you indicated that you hadn't seen that silver car earlier, is that correct?
No, I didn't see that silver car earlier.
Did you tell the police at some point you had seen the car earlier?
Yeah, when they had pulled up, yes.
I guess I want to be clear, how many times did you see the car pull up that day?
I had seen it pull up once that day. And then I went to the house to check on the kids, so I'm not very sure, like, if they did pull up. But I know when they pulled up, and my best friend was shot. She killed.
So maybe I'm misunderstanding. So you saw the car pull up,
Yes,
then you went inside
to check on the kids.
and then came back out. Was that car still there?
Yeah,
So the car never left.
that's what I was saying. I'm not for sure if it did leave or not.
And
But
just,
when they pulled up, I'm just not sure if it on time.
and just so we're clear, we're talking about the silver fusion, right?
Yeah,
Okay. When that fusion first pulled up, did you see anyone?
yeah.
What did you see?
So
What, if anything, did the individual you identified as Sosa do?
got up the car, and went over to the group of people that was outside.
Did you know any of those individuals?
Yeah,
Did you exchange any words with Sosa at that point?
no,
And then after Sosa gets back in the car, what does the car
they pulled it off.
do? Okay. So when they pulled off, the car did leave?
Yeah,
And then when was the next time you saw the silver fusion?
when it was pulling up on the side of the car.
Okay. About how long between when Sosa gets in the car and it pulls off to the next time you saw it?
Like 20, 30 minutes.
The last thing, Ms. Crowley, is you were talking about Sosa this morning. Do you see Sosa in the courtroom today?
Yes,
Can you tell me where do you see him and also an article of clothing that he's wearing?
the green jumpsuit. To the right.
And that'd be your right, just to make sure.
Yes,
If you're gonna ask for the record to reflect identification of the defendant.
So no,
Thank you. Your Honor, I have no further questions for Ms. Crowley at this time.
okay, before you cross the examine, Mr. Woodard, let me handle something real quick. Mr. Lamb. Mr. Lamb, are you there? Mr. Lamb going, oh, there he is.
Good morning, Judge King. Yes, I'm here.
Good morning, sir. So we have been waiting on you. I understand you're in trial somewhere. So I talked to the assistant prosecuting attorney. She indicated that her office may be dismissing this case because the complaining witness is deceased. So she's going to check back with me,
Understood.
okay?
Okay. So as it relates to next court hearings, should I just wait to hear from the court or?
Yeah, why don't you do that? But that late December date you received is a no-go,
Is it the December 20th? Understood.
okay? All right.
Okay, thank you, sir.
We are back on the record on People versus Gary Johnson. Mr. Woodard.
Thank you, Judge. Ma'am, good morning.
good morning.
I'm going to ask you some questions, and if you do not understand, please tell me, okay?
Okay,
And I'll try and make it so that we understand each other. Is that fair?
yeah,
I'm sorry.
yeah,
You knew Ms. Diamond for some period of time, years.
yes,
During the time of your relationship with Ms. Diamond, You had also met somebody you say that she was dating.
Yes,
That person, you know that person as Sosa, is that correct?
yes,
And I think you said that you had perhaps even gone out once or twice with this person you know as Sosa and your friend Dinah. Is that correct?
when you said going out,
Had you ever gone out with Miss Mitchell and Sosa?
no,
You had never gone out with Miss Mitchell and Sosa?
no, I didn't know they were dating, they saw me, no, I don't.
Okay, so before the incident that you described, before July 22nd of 2023, do I understand you to be testifying that before that date, you didn't know that Ms. Mitchell had dated Sosa?
No, I did not know they were dating,
Did you know that they had any kind of a relationship at all?
no,
Okay. And so if you testified today that you believe they did, is that because somebody told you that they did?
she did,
So somebody, meaning Ms. Mitchell, had told you that? Yes?
yes,
And had she told you that day?
yeah, she told me that they was dating when she fled to Kentucky with her,
Okay. And she told you that day?
yeah.
When this incident occurred, Ms. Crowley, it was dark, is that fair?
Yeah, coming into the morning, four start going on 5.
Okay, around 5 a.m., so it was still dark. Is that true? But maybe the sky was starting to lighten?
Yeah,
But it was still dark.
yeah, but it was in the morning.
Okay, cars still had their headlights on?
No, driving, what nobody out there driving.
Okay. This gray car that you say came by, or silver Fusion, did it have its lights on, do you know?
No, I wouldn't say.
Do you not remember, or do you remember that it did not?
I wouldn't say because it drove past, it came up shooting, so I don't think, no, I wasn't paying attention to car lights.
Okay. What about the first time you testified that that car came by? Did you notice whether its lights were on?
Yeah,
And what did you notice?
that the lights was on.
And I think you testified that it maybe would have been, how long in between the first time you said you saw that Fusion and the second time you said you saw it? Did you say about 20 minutes?
Yes,
And the second time the Fusion went by, is it fair to say that it did not stop?
yeah, but the second time?
The second time.
The second time is when she got shot, it did stop, it paused,
It paused.
and yeah, it stopped.
Okay. And it stopped next to Ms. Mitchell's car?
Yes,
Okay. And you just used the word pause. So is it fair to say that it just stopped for a quick second and then took off?
yeah,
You didn't hear anybody speaking?
no,
So when the police were at the scene there by your house, like in their immediate response, the police arrived. You talked to police while you were there. Is that fair?
yeah,
And they asked you questions about what had happened. Is that fair?
yeah,
Yes? Okay. And when you talked to the police on the scene, you were telling them what you had seen, correct?
yeah,
And is it fair to say that you described the person you believe to have been the shooter? You described that person by name to the police, right? At that time.
so one officer, yes, I did,
Okay. You told them the name of the person you thought did the shooter.
yeah,
And That name was Sosa?
No,
What was the name you gave to the officers at the scene?
oh, it was Sosa, but I talked to one officer, but I don't know her name.
Fair enough. I thank you for answering that question. I appreciate it. I understand what you said. But then, so at that moment, you believed that you knew who had done the shooting. Is that fair?
Yeah,
Okay. And so fast forward to later that morning, and you are giving a written statement to this gentleman here. Do you remember that?
yes,
And I'm pointing to, who am I pointing to?
Officer Cooper.
Okay. And so you actually sat down or spent some time with Officer Cooper preparing a written statement. Is that true?
Yes,
And did you see Officer Cooper writing on a piece of paper?
yes,
And Officer Cooper would ask you a question? Is that true?
yes,
And you would see him write down that question?
yes,
And then you would answer the question, right?
yes,
And he would write down your answer.
yes,
And Officer Cooper asked you who had done the shooting. Is that fair?
yes,
And you did not tell Officer Cooper that Sosa had done the shooting. Is that true?
that's correct.
Okay. Even though at that time in your mind, you knew that that was the truthful answer to that question.
Yeah, because I was scared of what happened to my best friend.
It had happened just a few hours before, right?
Yes,
It happened right in front of you.
yes,
It's natural that you would be scared, correct?
yes, because I could have got shot too.
You could have. And nonetheless, you didn't tell them the truth in that statement. Is that fair?
Yes,
Whatever your reasons for it. And I get it, but you didn't tell them the truth. Right?
correct.
6 days later, you went to the Detroit Police Headquarters, correct?
Yes,
Did the police come to your house and pick you up?
no,
You drove there yourself?
yes,
Had Detective Cooper asked you to come in at that time?
yes,
Did you meet Detective Cooper at the police headquarters on the 28th of July?
yes, yes,
You went up there, okay. And you went up there and you gave another written statement,
yes,
like the kind that you had given on the 22nd, correct?
the correct, yes,
Okay. And then in this second written statement on July 28th, you told the police that in fact it was a person you knew as Sosa, who you think had done the shooting, correct?
yes,
And is it your testimony that that was a truthful statement?
yeah,
Ms. Crowley, you said that that evening there had been some kind of a party on your block,
and
a couple of parties, a bunch of people.
a couple,
Okay. You said that when this silver fusion came by the first time, that the person you know as Sosa actually got out of it
yeah,
and walked over to a group of people,
yeah,
not the group that you were part of, but a different. Is that true?
yes,
And you said that there was someone in that group that, was there someone in that group that this person Sosa talked with?
yeah, his brother,
You said who?
his brother.
And at that time, is it fair to say that this person you knew as Sosa was driving that silver fusion?
No, he wasn't,
The first time that you say you saw the silver fusion, Sosa got out of it, but not out of the driver's seat?
no, he got out the passenger seat.
Judge, I don't have any other questions. Thank you. Thank you, Ms. Crowley.
Can you redirect?
No, Your Honor, thank you, I apologize.
Okay, I just want to make sure I have a good understanding of that's what's going on. This happened on DeSoto Street, Detroit, is that right?
Yeah.
And whose house was that you were at? It's your house. And your friend, Diamond, arrived at that house in the vehicle?
Yeah, actually, yes, yeah.
Okay. And the reason for coming there at that time of morning was what?
She was tired. She told me that she fell asleep at her home back in the parking lot. And then I was already babysitting the twins for her.
Oh, so you were babysitting, or she was coming to get her kids?
Yeah, but she was gonna lay down for a couple hours.
All right, and she was gonna lay down where?
In the house.
In the house? And while you were out there this time of morning, you said that this silver vehicle, what kind of vehicle was it?
A Ford Fusion.
Ford Fusion. And you said that the defendant, Mr. Johnson, was in that vehicle, is that right?
Yeah.
He was on the passenger side of the vehicle?
Yeah.
And you saw him get out the vehicle and approach some other people on the street?
Yeah, the first time.
Do you know who those other people were?
His brother.
His brother. All right. And did you and Diamond have any discussion about sending Mr. Johnson in the vehicle?
Yeah, I ended up with letting her know that he was out there. And she was getting ready to leave and text her friend.
So she wasn't in there. She wasn't in the car at the time.
She was
in the house.
No, she was in the car still. I ended up coming out the house from checking on the kids.
Okay.
She still was sitting in the car.
All right. So then Mr. Johnson, does he get back in the car?
He gets back in the silver car.
All right. Then what happened?
We pulled up towards, I believe that he had pulled, that was when he pulled off, but he ended up coming back around eventually. And then the shots was fired at my
Where were you standing at the time the shots were?
leaving inside the car with the door open.
Driver's side of the door?
No, on the passenger side.
Passenger side. I see. And she was still in the driver's seat?
Yes,
Then the shots rang out, you hit the ground.
yes.
Was there anyone else standing at the car at the time?
So,
You said your mother had went in the house and used the bathroom, is that right?
yes,
And shots rang out. What happened to Diamond?
she still waiting in the house because she fell on the ground on me. And then she ended up feeling like she was just like scared.
So Diamond was on the driver's side of the vehicle. When the shots rang out, she ended up on the passenger side of the vehicle where you were at, is that
Yeah.
right? And you said she was on top of you?
Yep, they ended up taking off inside the house and was laying on the floor.
Okay, so she was able to get out of the car and run into the house?
Yeah.
Okay. How many shots did you hear?
At least 4
4 or 5 shots. You weren't hit by any shots, right?
No.
How long had you known Mr. Johnson? The defendant?
For a couple years.
Couple years. Any questions based on my question?
Yes, briefly, Your Honor. Ms. Crowley, one thing I neglected to ask is you indicated that you had seen Sosa go, you indicated that you had seen Sosa go and speak to his brother, is that correct?
Yeah.
Okay. How long had you known Sosa's brother?
For a couple years, also years.
Okay, did you have any interactions with his brother that day?
No,
No? You never spoke to his brother that day?
no.
apologize, I'm confused. Thank you, Ms. Crowley. Judge, I have no further questions.
I do, Judge, yes, thank you. Ms. Crowley, I just want to follow up on one thing the judge asked you, okay?
Yes,
You said that you had gone in the house to check on the twins.
just twins, yes,
They were sleeping,
yes,
you came back out.
yeah,
And when you came back out, this Mitchell's car was parked in the street in front of your house.
just in front,
And the passenger side of her car was against the curb,
yes,
right? You walked up to the passenger car, side of the car. And you opened,
open the door,
it,
yes,
and
but I
you,
was leaning inside of the car talking to him.
got it, that's what I'm trying to picture that in my mind. So you're sort of leaning inside the car, Miss Mitchell is in the driver's seat, is the light in the car on?
Yeah, in radio,
And the radio's on? And sort of the first instant that you knew something was wrong was when the gunshots, the sound of the gunshots?
no, when I seen the gun pointed towards the window, pointing towards me, yes,
Okay, so that's what I guess, I appreciate your saying that. So is it your testimony that you were looking? And
directly at the hole of the gun, yes,
okay, so you could see past Miss Mitchell
yes,
and you could see there was a gun pointing at you.
yes,
And that's what you were focusing on?
yes. And I told my best friend, get down,
You said, get down, and right then you got down.
she got down too,
And is that when you heard the gunshots?
they went straight on.
Okay. So you didn't, and forgive me, I'm not trying to sound like a jerk here, I'm just trying to understand. You didn't see like the gun flames or anything like that, did you, with your eyes? You didn't see that, did you?
No, man.
Okay, you saw a gun, you looked at the gun,
And told her to get down, because next thing you know, it was shooting, it was firing.
and you dropped to the ground and you heard the gun shoot.
No, I said you heard it firing
Okay,
as I'm getting down.
thank you. You heard the sound of the gunfire.
Wasn't aiming at me, it's pointing directly towards us, I'm in the car too.
I appreciate your testimony. Is it fair to say, Ms. Crowley, that the reason you have said that Ms. Sosa was the person who did this is because you saw Sosa get into the passenger seat of that Silver Fusion earlier?
No, because I seen him holding the gun, leaning out the car and shooting it.
Okay, all right, because you didn't say that just now, you said you saw the gun, right? Yes,
Oh, yeah,
thank you very much.
But you saw the defendant, Mr. Sosa, also known as Mr. Johnson, prior.
yeah.
Thank you, you may step. Any other witnesses on behalf of the people? No, Judge. Any witnesses on behalf of the defendant?
No, Your Honor.
People?
Thank you, Your Honor. So I'm not gonna attempt to argue, I believe it's counts 2 and make sure I have the right number, Judge. 2 and 6, I don't believe there was any testimony about Ms. Anderson. She's not present today, Judge, so I'm not gonna find over on those charges. As it pertains to counts 1, 3, 4, 7, and 8, I move to bind over as charged and complaint warrant for those charges, Judge. Based on Ms. Crowley's testimony, she testified that the Silver Fusion occupied on the passenger side by the individual she knows as Sosa, pulled up to the address on DeSoto. In the early hours of July 22nd, 2023, here in the state of Detroit, County Wayne. She saw that individual get out of the car, get back in the car, leave, and come back about 30 minutes later, pulling up next to the silver SUV that was occupied by Diamond Mitchell, in which she was standing leaning over on, At that point, she sees a gun produced, held by the individual she identifies as Sosa, and then she gets down, telling her friend to get down, and the shots are fired out immediately. based on those facts, Judge, I think it's clear that that gun was pointed and shot at Miss Mitchell as well as Miss Crowley with the intent to murder. They were both standing in let me be clear. Miss Crowley was standing in a very close proximity to Miss Mitchell at the time the gunshots went off. It's very fortunate that she didn't get hit, but the gun, she testified, was pointed straight through the window towards Miss Mitchell and herself when she was occupied in that area. I think based on her testimony, as well as the identification of Miss Crowley and the elements of the charges that I'm asking the court to bind over on have been met. And I ask that you do so at this time. Thank you, Judge.
Your Honor, I do concur with the prosecutor that the charges related to this person, Anderson, should not be found over. I'd ask you to dismiss the counts 2 and the count 6, development felony firearm charge. As it relates to the others, Judge, I think it's important that the court takes into consideration who the testimony has been, by whom the testimony has been provided. That is by a woman who, for whatever reason, admits that during a crucial and important interview with the police, she lied. I recognize that the witness provided what she believes to be an explanation, but nonetheless, the fact remains. And I think that the fact that the witness lied during this crucial and important investigation should color everything that she says from there on. And I don't think the court should simply accept it as true or even sufficient to create a question of probable cause. And I would ask you not to find over on it.
So I believe the witness, Ms. Crowley, when she indicates that on this date, July 22nd, at the location of 8586 DeSoto Street, the city of Detroit, that she was with her friend, her best friend, at the vehicle that she had been babysitting for her best friend. As she went in to check on the children, she came back out after seeing the defendant enter this silver Fusion with this accident damage to it, that same vehicle pulled up alongside of the vehicle that Diamond Mitchell was in and began firing. Even if she told the police something different initially, in that she said that she didn't know who the person was. She indicates that she didn't, or was less than truthful at the time because she was afraid. Her best friend had just been gunned down right in front of her. She knows who these people are. She knows what they're capable of. I think it stands to reason why she would be a little hesitant about telling everything that she knows. But subsequent to that, she did come forth and indicate that it was in fact the defendant, and that she's known the defendant and his brother for approximately 2 years. I have no issue whatsoever in binding over on count 1, murder in first degree premeditated. Count 2, the people are not moving to bind over on. I think DeShonda Anderson must be the mother who was in the house at the time. Who was DeShonda? And
it's another person, Judge, it's unrelated to the Crowley judge.
Whoever that was, there's no evidence whatsoever that there was an assault with intent to murder on question of court was dismissed for insufficient evidence. Count 2, assault with intent to murder. Count 3, Lakeisha Crowley. Now, the evidence, as I understand it, is that this Crowley was on the passenger side of the vehicle. The defendant's vehicle was in the street, his passenger door closest to the driver's door of Ms. Mitchell. That he fired shots, and Ms. Crowley indicated that the gun was pointed directly at Diamond Mitchell. She told Diamond Mitchell to get down, and she hit the ground. Diamond Mitchell fell on top of her, getting out the car. It sounds to me as if this was intentional, that those shots were fired at Diamond Mitchell and Diamond Mitchell only. It doesn't even sound like Ms. Crowley was in the line of fire because between Ms. Crowley and the defendant was Diamond Mitchell, the intended target, and he hit his intended target. I'm not so sure that we have sufficient evidence for a bind over on assault and attempted murder with Keisha Crowley either. There most certainly is evidence that the defendant was a felon and should not have been in possession of a firearm. With method, burden, of probable cause as relates to count 4. Count 5 is the felon firearm to attach to the first degree murder. Court finds people with method, burden, of probable cause as relates to count 5. Count 6 is the assault and attempted murder. Court will dismiss that with insufficient evidence. That's the felon firearm as it relates to Shonda Anderson. Felon firearm as it relates to Ms. Crowley, also dismissed with insufficient evidence. The court will find over on count 8, felon in possession of the firearm. Felon firearm attached to that. So the court finding that those charges were committed in the city of Detroit, those charges being count 1, first degree murder premeditated, count 4, felon in possession of the firearm, count 5, felon firearm, count 8, felon firearm. Court finding those charges were committed in the city of Detroit, the court finding probable cause to believe this committed will bind it over to Lane County Third Circuit Court, criminal division of the proceedings. His arraignment only information date time will be December 14, 2023 at 9:05 a.m. Then it will be remanded to the custody of the Lane County Sheriff. Thank you. Thank you. I mean, as to those counts that are indicated.
Do you want me to fill out the form, Judge?
You are Mr. Hoover. Thank you.
Judge, I don't see any dismissal forms in the podium here. Do you have a copy of it?
I think he was running out yesterday.
Start filling out a very formal. Move to I was going to look it up.
Madam Clerk, what's the case number?
2358256.
Thank you, Mr. President. Thank you, Judge.
Thank you, sir. Have a good day.
Okay. Judge, you're canceling the writ then? They got it here.
Mr. Johnson.
Mr. Johnson needed a writ to get it here. Stand on.
Supervised release violation hold for the judge.
Maybe here for the ring.
I'm the judge at this point.
Yeah, my sense, Judge, I think the marshal's office is going to probably take it back there one way or the other. They're pretty controllable there.
As you see, I have no idea.
Judge, I would
I
ask,
check the dates and they just magically appear. They're here.
Yeah, right.
I would ask you to release the writ though, because I have had an issue across the street where there's a 36 writ, and it's not released. There's issues down the road with the wrong writ being, so just for simplicity's sake, I've got a contact at the U.S. Attorney's Office that got us to this point, so I just want to make sure.
Talk to these guys. I don't have.
Okay. Okay, thank you.
Thank you.
Yeah. Okay. Exactly. Nice.
Thank you, Judge. Have a good night.
Oh, that's not part.
What's in the appendix? You said you don't have it.
It'll be the year, a 0, and 4, 5, 7. You trying to find a name? Yeah, that's what.
That's still back there. Thank God. No. No, well, no.
Okay, hold on.
No, I'm good, thank you.
How about you? Want me to get you anything? Oh.
Well, it's here, then I don't know how.
So,
Yeah.
okay, he has more than one case.
He was ready,
No,
he sounded like,
Yeah, he's on a federal.
that's how he got it.
So he has to go back?
Yeah.
So do I need to prepare a writ, is that what you're saying?
No.
For him to go back?
There was a writ already. He's here on a writ, because I talked to the.
He wants to.
Sheriff. Yeah, I just want to cancel it, but.
Because I don't think it's necessary, because it's going back to Wayne County Jail, right?
No, he's supposed to go back the same, well, today, but.
That's what I'm saying, go back to the Wayne County
Yeah.
Jail, and then they make sure that it's back to,
I'm sure they're gonna come get us.
right. So I don't understand, but it is.
He's really seeing federal.
If it was drug distribution. It's out of West.
But it's,
Okay, well,
Yeah, I don't have anything.
If it's not there,
It's
I'll-
something that I need to do, and you know, other than that.
I'll follow up with this, that case too, and make sure they know. So,
I gotta get work for them to take it.
Thank you. Thank you, Judge. Have a good rest of
Hey,
your
we
week.
have a great day.
You too.
be in recess until 1:30.
You sound familiar. Yes. You sound so different. So silly. It's been so long, right? Where are you now? Yeah. So, oh, how you like it? Okay. If I could, I would. I don't have those type of ranks. I don't have that type of rank. Now this says Mark Hart is the attorney. Yeah, let's see. No. So in this case, it's still pending 36, so. Should finish something. I did say that, and then in case I get I can make changes here because it's not long over. But it's not change to make because Mark Harvey's. Well, you saw you filed an appearance, so you returned. Yeah, because they never put a name in it, they just said they put the defender's office. And then, oh, so yeah, you have to cost money. So. Let me see. Oh, 224-2888. Yeah, unless you can reach somebody on. You're welcome, and good hearing your voice. I could pick up on this, so I know, right? All right, you have a good day. Bye-bye. Six. Turner, we have an Erica Tucson would like to speak to you. Sure. Okay.
I was the victim of the road rage. I was the victim of the road rage.
You was the victim.
I was the victim.
Oh, a victim. Oh, wow.
With my horn in. They chased me from like Lookwood and Southfield Freeway at 6.
Wow. Did you call the police? Oh,
That's
okay.
right. Prosecution.
Oh, okay. Oh,
Arrested.
good. That's somebody blowing her.
It was wild out. That's what was hanging out. Some gang signs. I thought I was gonna be the
Oh, my God. Wow. You see that? That's so crazy. You don't know. You don't see that.
That's all.
Yeah. Yeah.
You want me to do it? Bill? Well,
Jesus.
I'm trying to keep that to myself so I got something to do.
yeah, I know, I should have been my computer. Usually we get pretty jammed though.
Tuesdays and Thursdays can get
Yeah.
especially if I don't have my Reginald's 3 cases. Say 2.
So you don't want nothing done? Okay, let me know.
Well, thanks for asking.
I'll be sitting over here.
Okay.
I'll see when you get extra.
Okay.
Yeah, right, a lunch.
Yeah.
Oh.
All right. I have to the, do you have my number? Yeah, one. Yeah, I have. And who was defended?
Position or what? Defendant.
Yes.
That's in the homicide. Homicide exam.
Homicide, it was Johnson. Let me run it. His last name is Epps.
Yes.
And then his first.
Yes.
First name.
K-E-L-A-N.
Sounds real familiar.
It was originally scheduled for today. But it sent him out for. Okay. So now, but the competency hearing, which you don't have to appear for, but it's March 11th.
Okay.
That's what tell us.
All right, thank you. Prosecutor.
Yeah, exactly.
Yeah, sure. All right, thank you. Have a good day.
Yeah. Yeah.
Problem. They don't show.
Yeah. Court, is she gonna be off all week?
You know, I have no.
Oh, it's not closed.
guess he was a gang or something. Guy that was just arraigned, at court. He was part of a gang or something.
Who is that?
The guy that just kept them like,
They all knew each other, so she was afraid of
right. I don't understand.
him. Yeah. I mean, she's babysitting the girl that got shot. They were her best friend.
Right.
Getting twins up, she had was babysitting the kids. And he was talking to his brother, so she knew who he was. Then found out later when she was talking to Diamond that they were dating. So they must have broke up or something, but then he ended up shooting her.
But see, that was the thing. That's like, what made him want to kill her? That's not.
Because they're goofy, you know, they can't deal with breakups, so they want to kill them.
Yeah, that's basically.
What it is, it's,
I mean,
passion, you know. It's so stupid.
Judge King's court, when he's sitting up.
Hey, Dylan, can you do a thing?
Sure.
When you look at, I'll give you a case number, can you look at December the 14th and see what APA are even listed on the written form?
You want me to get the file and look at all of it? Okay.
Yeah.
Okay.
Case number is 23 05939
On Dwight Neely.
Yeah, because the printer said it received that the AK somebody else, but on the ROA it's somebody else. So I just say on that form.
Okay, let me get it.
And another thing to say that you don't just use to that.
Yeah, and then I'll try to, I'm trying to. But, well, I was talking to the job since it got that, but they won't let me go. That's it. Oh, okay. No problem. Oh, okay, no problem. Thank you. Okay, all right. I will, I'm going to.
You married? You have kids?
Yes.
I have mine are all out of state. The daughter's in Florida and they both, my son's in San Diego. Yeah. I do a lot of FaceTime with my grandkids.
Yeah, you know, like, makes sense.
It is. I just don't like traveling, no holidays, it's so crazy. Right, right, because you know, they grow so fast. With COVID, I couldn't go down and see them and FaceTime. Did you bring your lunch?
I don't know if I want
Having to go cheese, I eat that.
it. Well, that's not.
Some kind of time.
Yeah. Oh, okay.
I gotta get allergy pills. This carpet just makes my nose.
Yeah, you probably.
Well, I took some this morning, but it keeps running.
So how are you? Good. You might not like.
Thank you very much.
That's right.
Thank you, sir. Yes, please. Yes, please. So, yeah.
By the way, I'm not sure.
Okay, thank you so much.
Yeah.
Hey, Judge.
I'm good, how are you?
Good.
Hello there.
Hey.
How you doing?
Okay.
They can't.
Okay. You can sit down.
Dad, grandma, all done.
So.
Yeah.
I'm
not. I don't want
No, neither do I.
You happy with the time here?
Yes, Dr. Yes.
You ready?
That's,
Yeah, it's going over. Brown one.
Mr. Brown, Mr. Brown, sir. I just saw him.
Oh.
I think you just stepped out. Maybe.
You went back.
restroom or something.
What about?
We went to the back of the house.
I'm standing for the guy.
Dr. Lee,
All right. Ready, Mr. Brown?
Yes, sir.
Case 2359570 for the state of Michigan versus defendant number 1, Alicia Renee Holloman. Defendant number 2, Avion Trader. Both defendants are charged in count 1 felony murder. Both defendants are charged in count 2 child abuse, first degree. Both defendants are charged in count 3 torture. Appearances for the record.
Good afternoon, Your Honor. Tina Ripley on behalf of the people, P83688.
Good afternoon, Your Honor. May it please the court. My name is Mark Brown. My PIN number is 39562. I'm here on behalf of Ms. Holland. Ms. Holland, would you state your name for the record, please? Thank you. I'm standing, I'm sorry. I'm standing for Ben Gotti, with your permission, is that correct? Is that you? So that's okay. Sorry.
And good afternoon, Your Honor. Good afternoon to your staff. Please call on the report. Mohammed Nasser, P7445, appearing on behalf of Mr. Trailer, trailer, standing behind me. Sir, please state your full name for the record.
All right, this matter was held in part and continued to today's date. Are we ready to proceed?
Yes, Your Honor.
How many witnesses do we have left?
I anticipate just one, Judge.
Okay.
Judge, for defense, I know there was a mutual sequestration order. I do see that there are some individuals seated within the courtroom.
All right.
Are they a party to this?
I don't know
I've
who
spoken
this
to
is.
the prosecutor, she doesn't.
Sir and ma'am. Can I have your names? What's your name, sir?
My name is Charles Lee.
You have any connection to this case, Mr. Lee? Okay, that's fine. Thank you, sir. Your name now? Trailer, are you related to the defendant? You're not a witness anywhere, are you? Okay, thanks. You may proceed. Also, ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time.
Thank you, Judge.
We have an exception for the
Yeah.
stand-in RIC.
Yes.
Any objection?
No, Judge.
No. All right. Okay, that being said, let's call you witness.
Thank you, Judge. People call Dr. Lee Lavin.
We have Dr. Lavin, Madam Court Reporter.
Yes.
Okay. Dr. Lavin, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you?
Yes, I do.
Thank you. Please have a seat. We'll just pass next to me. You can adjust that microphone to your left, speak to that, please. If you're ready, sir.
Good afternoon. Please state your name for the record.
My name is Dr. Lee Lang.
And how are you employed?
I am an assistant medical examiner at the Wayne County Medical Examiner's Office.
How long have you been employed as such?
I've been with the office my entire career, which has been 24 years.
Do you have to have any special education to be a medical examiner?
Yes.
And what is your education?
I got to graduate from medical school. I graduated from Wayne State University School of Medicine. I had to complete a residency in the field of anatomic pathology. I did that at the Detroit Medical Center. Then you do a fellowship in the field of forensic pathology. And then at the conclusion of all that training, you become board certified in both anatomic and forensic pathology.
And so what kind of experience do you have being a medical examiner?
As I said, I've been with the office for 24 years. In that time, I've autopsied over 9,000 cases. I've testified over 450 times. And I am in charge of the education in the office, and that includes our fellowship in forensic pathology.
And you mentioned that you've testified quite a number of times. Have you been certified as an expert before?
Yes, in each case.
And what have you been certified as an expert in?
Anatomic pathology and forensic pathology.
And Your Honor, I would move for Dr. Levy to be certified as an expert in anatomic and forensic pathology.
Judge, I have your objections for example.
For example, purposes, I have an objection.
All right, court makes findings that they testify as an expert in anatomic pathology and forensic pathology.
Thank you, Judge. Dr. Levy, did you get the chance to perform an autopsy on ME case number 23-13017?
Yes.
And who was that on?
That was on a 7-year-old boy with the name of Deshaun Williams.
How old was, you just said he was 7, sorry. How tall was he?
He was 4 feet 2 inches tall, and he weighed 51.
And have you currently authored a report on that autopsy?
Yes.
Your man, I approach.
You may.
He has been marked as full disclosure that it's 12. Can you tell me what it is that you can't do?
This is a copy of the 10-page autopsy report, as well as a copy of the 4 body diagrams that I authored on this case.
This is a fair and accurate representation of the report and the diagram that you authored in this case.
Yes.
And I move the admission of people reports within 12.
No objection. No objection. Admitted.
Thank you, Judge. And what is your role in doing an autopsy?
An autopsy is an examination of the body where we are documenting all findings that are present, whether they be scars, whether they be injuries or diseases. And then at the completion of that autopsy and the gathering of supporting tests and documents as necessary, I then conclude the cause of that death and the manner of that death.
So would it be fair to say that you do both an external and internal examination?
Yes.
And can you define for us what the word abrasion means?
Abrasion is a scraping of the surface of the skin.
And what is a contusion?
A contusion is a bruise.
What is a laceration?
A laceration is a split or tearing of the skin.
Split or tearing of the skin?
Yes.
And I want to go through your autopsy report in this case. And I want to start with your external examination. What's the first thing that you do in your external examination?
The first step is, of course, documenting the identifying features such as scars, hair color, eye color. But then the main part of the external exam is the documentation of injuries that were present on the body.
And in this case, what do you see when you observe Deshaun Williams?
That he had extensive injuries present all over his body. Specifically, he had at least 225 abrasions on his head, neck, chest, abdomen, pelvis, back, buttocks, hips, and all four extremities. And in looking at the body, bruising covered 45% of the surface area.
I want to talk about your external observations of his head and his neck. Tell me about what you saw on his head and his neck.
Referring to my report on page 3, because the injuries are so extensive. Starting on the head and neck, areas of bruising were present on the glabella, which is the area between the eyes.
Judge, I would object to reading the report. You can look at it to refresh it.
Judge, the report's been admitted into evidence. Thank you.
The right forehead, the right cheek, left forehead, left upper eyelid, and the left cheek and the left jaw. Moving to areas of abrasions, there were multiple areas containing multiple abrasions. The bilateral forehead, between the eyes, on the upper eyelids, on the cheeks, on the nose, on the chin, as well as the front and both sides of the neck, and a pattern abrasion behind the right. Then moving on to other injuries, there were also on the head burns present. There was symmetrical burning, or I'm sorry, some circumferential burning of the right nostril. There was focal burn on the left nostril. There were burns on the inside of the lips. And there was also a burn behind the left ear. And then finally, for trauma on the head and neck, there were lacerations present on the inside of his lung.
So going back to the burns, you used the word circumferential and what was the other one that you were referring to?
Focal and circular.
So what's focal mean?
Focal just means it is just present for a small area. If you're staring at the nostril, there's only a small area that was burned. Circumferential means the entire entrance to the nostril was burned.
And how about the head and neck internally?
Internally, when the scalp was reflected, there were 10 bruises on the undersurface of the bifrontal scalp. There was also an area of bleeding between the scalp and the skull that was on the left top of the head. Once the skull was removed, There was bleeding present between the skull and the brain. This is called subdural hemorrhage. This covered the entire right half of his brain. On the surface of the brain, there were 3 separate areas of bleeding. These are called subarachnoid hemorrhages, and this was on the right top and the bilateral undersurface of the brain. And then finally, there was brain swelling.
And tell me about the timing and effect of these injuries to the brain.
Looking at the internal head injuries, subdural bleeding is not a fast bleed. It's not that arteries were torn. These are veins that are torn. I do not know at what point he lost consciousness. He could have lost consciousness immediately or toward the end of the process. But a subdural hematoma from trauma left unattended would take several hours to die from. The blood clot increases to such a size that it will just push the brain out of the way. And then you will see brain herniation. In this case, we had all the findings up to herniation.
And are you familiar with the term midline shift?
Yes.
Tell me what that means.
That is something you commonly see as the end effect of a subdural hemorrhage. For instance, this one is on the right side of the brain. It eventually will push the right half of the brain out of the way and into the left part of your skull. So that it would cause a shift, a midline shift from right to left in this case.
So did you see a midline shift in this
No.
case? And what does that tell?
That tells me that he died before the final effect of the head injuries.
And do you have like a hours or time frame that the bleeding would have had for like midline shift didn't happen?
No, all I know is the usual progression. However, in this case, because there was also significant trauma elsewhere, the 2 traumas occurring at the same time were likely the reason why he died before the end effect of the head injuries.
I'm sorry. Your voice is trailing the end there. I didn't hear the last.
Oh, that both of the traumas happened together and ended his life earlier than just the head injuries alone would have.
And I want to move on to injuries to the torso. Let's talk about external injuries to the torso. What did we have by way of contusion or bruises?
On the torso, bruises accounted for the majority of the skin and 25% of his body surface area. And on the torso alone, which again includes the chest, the abdomen, the pelvis, the back, the buttocks, the hips, and the flank, there were over 120 abrasions present. So in essence, the majority of this child's surface was covered on the torso either by a bruise or an abrasion.
And where were those, I guess, where were they located?
Pretty much all over. There were significantly, it was on the mid chest, the upper chest, the lower chest, both sides of the flank. There were several pattern abrasions that were present in this location.
You're just talking about abrasions. What about contusions?
Contusions on the torso included the mid-upper chest, bilateral upper chest, bilateral upper abdomen, bilateral lower abdomen, both sides of the flank, both hips, as well as the bilateral mid and lower back. There was also a large bruise on the front of the pelvis.
And did that large bruise on the front of the pelvis, does that pattern or resemble something?
No.
And what about the internal examination of the torso?
Starting with reflection of the skin, there were 3 areas of hemorrhage underneath the skin indicating injury. That was on, one was on the left upper back, and the other 2 were on the bilateral lower back, lower flank area. Then proceeding to the body, the injuries were confined to the abdomen and the pelvis. There was a convoluted fracture of his pelvis, which means it's fractured into multiple pieces. And there was separation of his pelvic bones from the anterior midline. So in essence, his pelvis was split apart. There was bleeding in the pelvic cavity as a result of that into the back of the abdomen, which is known as the retroperitoneum. There were also contusions on the back of the right diaphragm, on the right colon, and there was fracture of the one right rib. That was the 12th rib.
So that pelvis fracture that you talked about, what did that cause?
Well, once he sustained that injury, he would have been unable to walk. And eventually, after several hours, it left unattended. He was losing enough of his blood volume and go into shock and died. And there was some bleeding in the abdomen, but I would not say that he lost the majority of his blood volume.
And what does that tell you about the timing of that injury?
Again, it's very similar to the head injuries. If left unattended and without other injuries, it would take several hours to go into shock and die from his pelvic injury. The fact that we don't see a lot of bleeding tells me that the head injuries were going on at the same time, and again, resulted in his death before either of the two injuries would have gone to their natural conclusion.
And we're talking about the pelvis bone here. What kind of force is needed to break that bone?
It actually takes quite a lot of force, particularly in a child. Children's bones have a higher water content and their supporting tissues are more elastic. So they can withstand forces and traumas much greater than an adult. As a result of that, we very rarely see pelvic fractures like this in children. When we do see them, it would be in a complex motor vehicle accident. Complex being my word for high rate of speed, extensive damage to the car, conditions like the vehicle rolling over and the seat being ejected. We can also see this pelvic injury in fall from a great height, meaning higher than 2 stories. In terms of inflicted injuries, this is very rare because of the amount of force needed to cause this.
You just used the term inflicted injuries. Tell me, what does that mean?
That means that these injuries were inflicted upon the decedent. He did not do them himself, and this was not injuries that he had somehow sustained in a fall. The external injuries as well as the internal injuries were beyond his capability to inflict onto himself.
I'm sorry, maybe I missed a word. Did you ever say self-inflicted? Did you say inflicted?
Inflicted upon himself. I guess more words to say self-inflicted. These injuries were not self-inflicted.
I apologize. I'm just.
That's okay. In your internal and external observations of the torso, did you get a chance to identify that was his buttocks?
Yes.
And was there anything that you noted about the skin on his buttocks?
That the buttocks had scars that were consistent with living. The skin on each buttock was thickened and hypertrophic from repetitive trauma, and it was more darkly pigmented. And there were multiple faint scars cross-hatching each buttock. And these are scars from a whipping or from multiple whippings.
Now I want to talk about the extremities. What were the injuries on his right upper extremity?
On his right upper extremity, there was diffuse bruising of the lateral aspect of the upper arm and forearm, as well as the hand. And there were abrasions, some of which were patterned on both shoulders. So it would be on the right shoulder, as well as additional abrasions on his right upper arm, his right elbow, his right forearm, and his right.
And just for clarity purposes, when you say pattern, what do you mean when you use that term?
Sometimes when you are struck with an object, the injury, at least on the skin, resembles the object. So we would call that a patterned injury. They are not very common However, in this case, there were at least 8 patterned injuries that could be easily identified.
Amen.
Screenshot of both one speed along with Olivia 5, photos 173, and people 7, photo 97. What those are the next.
The first appears to be a screenshot of an adult male holding what I'll assume to be the child. You can tell that there is a child resting in his arms or on his lap. The head of the child is not visible. On this child, I can very clearly see one of the abrasions present on the right arm, the one that is on near the back of the elbow. The other ones are a very close-up of abrasions on the back of an elbow. This did not originate from our office, but it is consistent with the injury on this child's right arm. And then finally, the last picture is the autopsy photo showing that this is indeed the abrasion that was present on the right arm just a little bit.
The other people are good, but I moved for the original screenshot. One C, I think it was proposed 13.
No objection. No objection, Your Honor. They made it. Yes.
And what about the injuries to his left upper extremity?
On his left upper extremity, there were bruises, multiple, on the upper arm, elbow, and his forearm and hand were diffusely bruised along the lateral aspect. And then there were abrasions, again, some pattern that were on the left shoulder, the front and back of the left elbow, the left forearm, and the left wrist and knee.
And what about on his right lower extremity?
Right lower extremity, there, the bruising was on the lower thigh, as well as the lower leg. And then there were abrasions on his right thigh, multiple, the right knee, multiple, the right lower leg, the right ankle, and on his second toe.
And what about his left lower extremity?
On the left lower extremity, there was diffuse bruising present on the front and lower thigh, with multiple contusions on the lower leg and foot. There were abrasions on the left thigh, the left knee, the lower leg, as well as the foot and the forefoot.
Now, I want to talk about you talked about this a little bit, skin reflection.
Yes.
What do you mean when you say that?
When we see inflicted injuries, we reflect the skin, which means we peel the skin off of the underlying tissues. And we do that to gives us an idea of how many of the injuries were impactful enough to cause underlying contusion and likely related to internal injuries versus they were just injuries that were on only the surface of the skin with nothing present, no abnormality underneath.
And did you do that in this case? And what did you see?
When we reflected the skin, the only areas where there were underlying hemorrhaging or bruising was again on the frontal scalp and the left upper back soft tissues and the bilateral lower back soft tissues. The remainder of the skin, when it was reflected from all other surfaces, did not show any underlying abnormalities.
So the bruises were skin level, not deep.
Yes, except for the ones in the head and
And what does that tell you about the bruises? Tell you anything about the bruises?
Well, when we see extensive external injuries without any underlying contusions, the skin is the organ of the body that has the highest pain receptors. So when you see extensive external injuries with no underlying internal injuries, these therefore would be injuries that were inflicted to cause pain and not meant to jeopardize someone's life. Some people might use the term torture, some might use corporal punishment. But the majority of injuries on this child were not associated with underlying serious injuries.
And now I want to talk to you. Did you see any injuries that would be classified as post-mortem?
Yes.
And tell me what you mean by post-mortem.
When you're alive and you're injured, the injuries show what is known as a vital reaction. They're moist. They can actually leak fluid. They will have reddened edges and a reddened base. And certainly the contusions and abrasions that I've already talked about had. There were 2 injuries or areas of injury that were post-mortem. And when the body is injured post-mortem, there's no beating heart. So these are injuries that lack that vital reaction. They appear dry and they're certainly not red, have reddened edges. So they will just look like dried up. In this case, there were 2 post-mortem injuries. First was a laceration of the perianal skin. And then the second were areas of second-degree burns on the right lower leg.
And just clarity purposes, when you say perianal, what is that?
That's the skin going around the anus.
And now to your internal examination. What did you find in your internal examination?
Other than the head injuries and the pelvic injuries, there were no other injuries and there were no diseases.
What were the effects of these injuries?
Do you mean in terms of resulting in death or functionality?
It's what functionality.
As I already stated with head injuries, you don't know when, you can't predict when someone will lose consciousness. He could have lost consciousness early on in the beating, or it could have been at the very end when the bleeding had reached its critical point. And it would have taken, again, several hours if that was the only injury present. Pelvic injuries, you would not have been able to walk after the pelvic fracture. And again, it would have taken several hours for him to lose enough blood volume to go into shock and die from that injury.
And I'm thinking about the timing of the injuries. Is there a way to tell if they're old, new, fresh? We talked about post-mortem, but what did you see in this case?
With regards to external injuries, in this case, they were all recent, meaning looking at the injuries on the skin that they were inflicted within 24 hours. When abrasions start to heal, they form scabs, and none of these abrasions had scabs. And when bruises start to heal, they turn colors, and none of these contusions turned colors. So they were all injuries inflicted within 24 hours.
Did you have any old scars?
Oh, yes, there were numerous scars present, starting on the forehead and the eyelids and going down to his legs. Some of them were typical scars you see with active children, like on the knees and the shins. Others, like the ones on his upper eyelids, are not typical locations for self-inflicted injuries. And then, of course, there was the living scarring on his eyes.
Tell me about the ones on his eyelids.
Again, this is not a classic location for injuries on a child, and they were in the same location as current abrasions. So I guess that would suggest that this indicates a repetitive nature to this abuse, because we have old scars and fresh injuries in the same location that again are atypical or typical childhood injuries.
Were all of the bruises that you saw on him of the same color?
Yes.
As a medical examiner, what is your role in reporting the autopsy?
Again, it's to determine the cause of death and the manner of death, to identify any factors that could be contributing. With regards to injuries, it's to provide information that could relate to how the injuries got there, for instance, patterned injuries. And also to, based on medical experience and expertise, be able to opine on things like pain, suffering, or how long until some that particular injury will result in death.
And talk about determining cause of death. What do you mean by cause of death?
Cause of death is the exact injury or disease that ended the life. A common example would be like a gunshot wound or a heart.
Did you come up with the cause of death in this case?
Yes, the cause of death was multiple blunt force injuries.
And you also mentioned that you determine manner of death. Tell me what do you mean by manner of death?
Manner of death is looking at the circumstances around which the death occurred. And for cases of trauma, it essentially comes down to police investigation as to whether they think someone inflicted these injuries or the child did them themselves. And the police indicated that, again, this was not self-inflicted, that someone.
I'm gonna check anything police may have said.
Sustained.
So, without saying what you're not saying what the police said in this case, just like what? Where she gets information from.
Rephrase.
Yes, Judge. When you gather information surrounding the case, is it fair to say that you review all different kinds of things?
Yes.
And what are some of those things that you review?
In this case, it was the medical records from Children's Hospital and the Detroit Police report of incident on relating to this case.
And those things don't tell you how to come up with a manner of death, do they? Okay. And your manner of death comes from what you observe on the body?
Yes. In conjunction with these circumstances, my determining this to be a homicide simply means that the death was caused by another person. That's without any idea of who or their intent. That is the medical examiner definition of homicide.
So it's not a legal term.
Right.
It's very different from the legal term homicide.
Yes, very.
And you came to the manner of death as homicide in this case?
Yes.
Dr. Larry, did you have an opportunity to observe some items that were recovered from the house in question in this case?
Yes. The day of autopsy, I spoke to Officer James and indicated that there were patterned injuries present. I described the patterned injuries and then suggested that there might be objects that would fit those descriptions. And on November 14th, she, along with the objects and you, came to our office to have the objects photographed and to have them compared to the patterned injuries in question.
And what are the items that you had a chance to observe?
The items that were brought in were a wire coat hanger that had been twisted to have a loop at one end, long straight parts, and then the other end of the the hanger was twisted together. There were two belts that were brought in. One had a more squared off, so I described it as a block shaped buckle. The other one had a semicircular buckle. In addition, objects that were white metal and cylindrical, 1/4 inch thick, and they had a white ball at the end of it. I'm not sure what that object was to begin with. And then there was also a large circular object. It appeared to be the base was made out of the same material as the white pieces. And the base formed a circle that was 6 inches wide. These were the objects that were brought.
And what did you do in your role with these items?
We had our photographers photograph each of these objects using the same scale as the patterned injuries on the decedent. We then had our photographers doing a 1-to-1 comparison, placed the object next to the pictures of these injuries to indeed show the injuries that were consistent with those objects.
And what injuries or marks on the body were you able to identify an object for, if any?
Certainly. Starting with the hanger, there was a loop abrasion behind the right ear that was consistent with the loop end of that. Several of the linear abrasions present on the body were of the same, were narrow or thin, as I described them in the report, and they were the same thickness as the long portions of the hanger. And then there was a twisted pattern injury on the left cheek that was consistent with the twisted end of that hanger. Moving on to the belt with the block-shaped buckle formed a pattern injury on the left cheek and on the right shoulder. The semicircular belt buckle caused injuries on the right cheek, the left neck, and the left shoulder. The prong and bar from one of these belts, I do not know which, formed L-shaped injuries on the left forehead and on the left shoulder. The thicker or quarter-inch thickness white metal pieces formed were the consistent diameter and width of a lot of the abrasions on his body. The circular base fit a patterned injury on his left lower flanking hip. And then in addition, there were two other pattern injuries. One is a scrape abrasion from being dragged across a roughened surface. It's known as brush burn abrasion. This was present on the body. Again, is a pattern injury, although not to an object, more to flooring. And then finally, there were three impacts present on him that resembled shoe treads, but no shoes were brought in for me to examine.
And then you mentioned your photographers, were photos taken of the autopsy and of the objects and their comparisons to his injuries?
Yes, photographs were taken externally as well as internal injuries, as well as after the brain was fixed and sectioned. Photographs of the objects alone with a scale, and then doing the comparison of injury photographs to the items. Those were all of the areas that our photographers took pictures under my direction.
May I approach?
Ma'am?
Many of our exposure exhibit 7. Can you tell me what that is?
Yes, this is a photocopies of the photographs taken in this space, all totaling 203 photographs.
Are those fair and accurate representation of the photos that all the stuff actually occurred in this case?
Yes, and they represent the injuries as it is on.
Alright, the addition of 7.
Objection for purposes of likewise, thank you.
May I? Sorry. Now, we talked about some of the burns on Deshaun's body. Those being some of the nostrils.
Yes.
May I approach?
Ma'am.
Community is marked as equals 4, number 79, equals 6, number 199.
Okay.
What are those like?
These are two photographs showing that what was on a wooden dresser is a lighter that has a red handle and a long. It's a lighter that you use when you're trying to light something far away from what you're doing, so it's like a flicker. sorry, I don't actually know the official word for this item, but that is what is able to be.
Would a lighter like that, would that be consistent with burns in the knot?
Yes, any circular object that could burn could have caused those burns, the burns in the mouth and the one behind the ear.
Yes.
I want to talk about the burns on his other burns on his body, which I believe you said were there was some on his ears and then on his legs.
Yes, there was one behind the left ear that was inflicted while he was alive, and then there were 3 on his right lower leg that happened after his death.
Can hot water cause these kinds of burns?
Yes, hot water, if it's over 130 degrees Fahrenheit, can within a matter of seconds burn, and you can burn skin and blister it whether the person is alive or if they've already passed. Again, it burns may be different, but you can burn a body that of someone who's no longer alive.
And tell me about can generally tap water get high enough to burn?
Yes, they recommend keeping your hot water tank at 120 degrees, because at that temperature, it would take almost 15 minutes of constant hot water to burn. However, individuals can leave their hot water tank at whatever temperature they want. So it is entirely possible that tap water could get to 130 degrees or higher and cause these burns.
The burns consistent with hot water, where are they on the body?
That was on the right lower leg.
And are those burns inconsistent with water causing them?
Yes.
I'll go anything for that.
Okay, please support. Good afternoon, doctor.
Good afternoon.
Doctor, I'm gonna ask you some questions. If you don't understand, please let me know. I'll try to rephrase them the way that you can't understand. Is that fair?
Yes.
Now, you've already indicated you had the opportunity to examine Deshaun Williams, correct?
Yes.
And you've authored a report which the fine prosecutor has been questioning you on, correct?
Yes.
And you make the determination that there are, well, not determination, you viewed and examined the number of bruising, scarring, and stuff on this young body, correct? Okay, and you would agree with me that we don't have an exact timeline. You indicated that the abrasions were fresh within 24 hours. Is that fair?
Yes.
Okay, now is that a hard and fast 24 hours, or do you know exactly when?
No, there's no way to know exactly, but most abrasions start scabbing at the 24-hour mark.
Okay, but that varies from body to body, individuals and stuff of that nature, right?
Yes.
So your best estimate would be within 24 hours, right?
Yes.
Okay, now let me ask you this. Now, let's talk about, Sister Counsel asked you about items that were brought to you for examination. Remember that?
Yes.
And you talked about a hanger and a belt, stuff of that nature, right? Now, when this hanger was brought to you, was it in a hanger form or was it unraveled, for lack of better terms?
I know it was a hanger that had been twisted. As I indicated, the one end just formed a loop, and then the two longer metal pieces were just sort of forming a long bar, and then the other end of it was twisted together.
Okay, now this is just a standard hanger that you can get anywhere, correct?
Yeah.
So there was no type of forensics to determine whether or not this particular hanger caused this injury. It's just a hanger, correct?
Correct. The injuries were consistent with a hanger doing it, but whether it was that exact hanger, I do not know.
Okay, now what about the belts? Do you remember looking at some belts?
Yes.
Okay, were they men's belts, women's belts?
That I couldn't tell you. One was wider or thicker than the other, but I only distinguished them based on their buttons.
Okay, now can you determine the period of time that these particular items, you saw scarring that's consistent with these items, correct?
I saw fresh injuries that were consistent with these items.
Okay, and that would be, again, your best bet about 24 hours or so, correct?
Yes.
Okay, understood. Let's talk about the burns. You remember the burns?
Yes.
Okay, now sister counsel showed you, oh, you remember taking a look at pictures and you were looking at something like a lighter that you defined, correct?
Yes.
Did you actually examine that lighter?
No.
You know whether or not that lighter was workable, working, not working?
No.
So you don't know whether or not, it's just a standard lighter that you can buy at any gas station or any store, correct?
Yes.
That you, me, anyone else may have in their home, agree?
Yes.
Okay, so while you were shown pictures, you were never actually examined the lighter and see whether or not this particular lighter was functional or could have caused these injuries, right? Okay, you talked about shoe prints, agree?
Yes.
You were never given any shoes, were you?
Right. I was never graded.
The scarring that was seen on this body, we can't testify with any specificity how long that scarring has been on the body, can we?
No.
Okay. It's fair to say that you are able to determine something between something that is a fresh abrasion or whatever have you within 24 hours or so, and then between some of this scarring that's been there for perhaps an extended period of time, right?
Right.
Okay. Now, you determined the cause of death being multiple blunt force trauma, correct? Multiple blunt force trauma. Can we state with specificity what timeline those blunt force traumas took place?
Again, based on the internal use of the head and the pelvis, that it would have been within a few hours preceding his death.
Okay, now when you say few, does that mean 2, does that mean 4?
It's intentionally vague because we do not know the exact time. It could have been 1 hour, it could have been 3 or 4 hours. I do not know.
Okay. Is there a maximum time, allowable time that you're talking about when we speak about hours? Could it have been 10 hours?
No, I think the maximum would have been what I tested, 5 to 3 to 4.
3 to 4 hours.
Yes, or as little as an hour or.
Okay. Now you testified about, you said that the abrasions that you found on this young man when examining his body, that you made the determination that they were not self-inflicted, is that correct?
Yes, that in total, these injuries were not self-inflicted.
What does that mean, please?
It means that maybe 1 or 2 of the abrasions on his body, he could have just done naturally throughout the day before his death.
Okay.
But given the total number, the pattern of injuries and the injuries to the head and to the back that resulted in his death, that could not have done those.
Again, that's certainly your professional opinion, and we didn't make a determination specifically about some that could have been self-inflicted and some not self-inflicted, stuff of that nature. It's just the totality of the circumstances, correct? Or the totality of your examination.
Yes.
Okay. The judge already asked you, but you said that there was some burning on a particular leg that you extrapolate came from hot water?
Yes.
Okay, what leg was that?
That was on the right leg, the right lower leg.
Right lower leg. Do you have a determination of how long that particular bruise was present, or that particular injury was present?
No, it happened after he died, so there's no way for me to do that.
Okay. So while you state that there's multiple blunt force traumas that cause this unfortunate loss, can you identify with specificity which blunt force trauma caused it?
It would be the blunt force injuries to the head and the blunt force injuries to the lower back flank.
Head and lower back?
Yes.
Does that include the pelvic area or?
Yes, yes, that would be posterior, so it would have been below to his lower back and the sides of his back that caused the pelvic injury. So I guess to make it easier, the head and pelvic injuries in total, those were the injuries that resulted in.
Okay, now, that's predicated upon certainly your examination, correct? And it's fair to say that this young man, young boy, in examining his body, you found trauma or signs of trauma that are old as well, correct?
There were scars.
Scars.
Yeah, but all of the injuries, the bruises and the abrasions were all fresh.
Okay. Did the bruising or the injuries possibly caused by the bruising that you saw have an aggravating effect or would have expedited or caused someone to respond or die quicker? Is that a possibility?
No, again, most of the injuries, except for the ones to the back, pelvis, and head, were superficial and limited to the skin. So they, again, other than injury and pain, they had no, there was no ill effect toward his health or his life as a result.
Okay, so what injury, so you said, how much injury was to his head?
On his head, there were over 40 abrasions and bruising on, well, 3% of his body area and on multiple places on his head.
Okay.
And then when we reflected the scalp, there were 10 separate bruises indicating 10 separate impacts that you couldn't see because of the child's hair.
Okay. Now, some of this led to internal bleeding, right?
Yes.
Okay, I don't have any questions. Thank you.
Definitely not.
Good afternoon.
I'm gonna ask you some questions, and a lot of times the questions are not very clear. If they're not, please let me know. I'll cover.
Yes.
First thing is that maybe my hearing or whatever, but I asked you earlier about inflicted or self-inflicted. You said you were using it interchangeably. Is that correct?
I was saying the injuries inflicted by someone else or not self-inflicted.
Okay, so you weren't using it. So when you say inflicted injuries, you mean by someone else? When you say self-inflicted, you mean by the child?
Yes, yes.
Okay. And just, maybe I'm being redundant on one of you, but you said that the majority of the injuries that you found, instead of 225 abrasions and that sort of thing, 45% of black with bruises, that's not possible.
Oh, well, the injuries on the head and on the lower back pelvis, certainly yes, but the majority of the injuries that were on the rest of his torso, his neck and his extremities did not contribute to his heart attacks.
Okay, but just so I'm clear, the bruises are not the cause of death. The bruises.
Well, the bruises represent impacts along with the abrasions.
I'm interrupting you because I would like an answer to my question.
No, I think that's argumentative. She's trying to answer the question. It takes more than just a yes or no.
My question was a simple question. I'm not so that. I asked were the bruises
may not result in a simple answer.
Pardon me?
It may not result in a simple answer. Let's let her get her answer out.
A bruise on the skin with no underlying injuries did not contribute to death. Bruises on the body that had underlying injuries and they resulted in death, those bruises, yes, I would say did contribute to death.
Okay. So the bruises that you're talking about that would be contributors to the death of this child would be the bruises to the lower back and flank and to the head.
Yes.
And there were the specific bruises to the lower back that you were talking about.
That there were the shoe imprints were present there on the sides of the lower back as well as on the left side of the flank, which is the torso. And there was also extensive other abrasions present and bruising. All of this representing impacts to that area that caused the internal injuries.
And just so we're clear, you're saying shoe imprints. You were never, I don't want to ask the same question. You were never provided with shoes, right?
That is correct.
And you never.
But it's just that a pattern that is repeated on the body, and to me, very well could represent a shoe track. I imparted that information, but I was never brought any footwear to examine with regards to those injuries.
So you're talking about something that's possible, but you have no way in this particular case to say that was the cause?
Yes.
Okay. Yes. And then on the bruise to the head, was that on one side that would be the cause of death?
No, these were bruises going across all in the center of the head, on both sides of the forehead, and on the undersurface of the scalp, they're scattered throughout both sides. So this would impact to both sides of his head, not just.
Actually, were any of those patterns,
The ones to the forehead, yes, there was an L-shaped one from one of the belts, and then injuries present on his cheeks were from the other belts and from the wire.
Okay, so the injury to his cheek would be a cause of death?
I know, but it could represent, and the impact could, that represented the death, but most likely the injuries from the lower face down were not. It was the blows to the forehead and upper area that related to the trauma.
Maybe I misheard. You said the injuries could represent what you saying? The facial.
Oh, the ones that were present on the cheeks and the lower face, again, they didn't go beyond the skin. So they would not have contributed to the internal head injuries. It was the ones on the forehead and the higher parts of it.
Okay. And then indeed, one of the ones you just mentioned, the forehead, there was a one that you associated with a belt buckle.
Yes.
And that could be a cause of death.
That blow added to the impacts and caused the head injuries. So yes, I would say.
I understand. My question is very specific. That blow could be a cause of death. That blow.
Yes.
Itself.
Yes, the
alone.
one to that alone.
Yes, ma'am.
I would say then, I can't really answer. I would say there is a possibility that one single blow would not have resulted in his death.
You have no opinion whatsoever in terms of order of injuries.
Correct.
Yeah. So and just so I'm clear, I'm going to rewind a little bit to the so if the example you used was a motor vehicle accident would cause the type of injury to the pelvic area.
Yes.
That's not the only thing that causes it.
Correct. We can also see anything that can generate a great force. So a fall from a height higher than 2 stories, or what I labeled as a complex motor vehicle accident. This pelvic fracture is not a commonly found injury in child abuse simply because the amount of force it takes to cause this injury is not one that most people can generate.
Okay, you said something very interesting. You said this type of fracture is not common in child abuse.
Yes.
Okay, but I'm not talking about what the overall thing is. This type of fracture can be caused by a motor vehicle accident or a fall from, you said 2 stories?
A grade height meaning higher than 1 or 2 stories.
Okay, so one could be 1 story.
No, it was from a grade height. A grade height would be over 2 stories, which is what a common house.
I know. I apologize to you. And I'm just saying when I asked the question, you said 1 or 2 stories. That's what you said. You want to change that now?
I know what I said was that it was a fall above. It was not 1 or 2 stories. The fall from a great height would imply over 2 stories.
Okay. And the injury to the pelvic area, that would be something that would take some time because that would be in terms of cause of death, because that would require great loss of blood.
Yes.
And that wasn't what you found in this autopsy, is that correct?
That is correct. The pelvic bone was very obviously fractured and split in half, and there was some bleeding, but there was not the amount of bleeding that one would associate as someone who died from just that injury.
Okay, so that really would not be the cause of death.
I know, it is. It definitely, if it was by itself, that injury can cause death, the same as the head injury. So yes.
Your objective is not to determine what could have caused death, it's what caused death. Is that correct?
Yes, and
okay,
it's
so,
the injuries to the head and to the pelvis.
But you just said that the pelvis, there wasn't a loss of blood that would be consistent with that being the cause of death.
No, but it wasn't that amount of blood that would be consistent with that, the end stage of that injury alone.
Okay.
That because these 2 injuries were occurring at the same time, they acted together and ended his life before the pelvic fractures or the head injuries would have developed to their end conclusion.
I didn't understand. You said you had no idea about the order of injuries. Is that correct?
Oh, yes, I can't look at these injuries and say which one occurred, but the head injuries and the pelvic injuries were being inflicted at the same time.
Okay. What time, approximately what time? I mean, I don't need time on clock, but time before that.
Time before death, again, it would have to have been within a few hours because he could not have survived longer than a few hours with either the head injuries or the pelvic injuries.
Okay, so is it the same progression, the injuries that were suffered in terms of the head trauma? There's a time period for that.
Yes.
How much, what's that time?
Would be, again, the same, usually several hours, just like with the pelvis.
It's the same as the pelvis?
At the same time frame, different mechanisms going on, but because we're not talking about arterial blood or immediate loss of a vital function, it has to take enough blood in the head, enough bleeding along with the brain swelling, and then eventually resulting in brain herniation. In the abdomen, it's bleeding at a rate so that you eventually will lose enough of your blood volume and go into shock.
Okay, but is, you have, I don't know, is medical, in terms of medical standards or whatever, there's something that says that the time that it would take for what we see as the result of injuries to the head would be the same as the injuries that were observed.
No, it just happens that they both, my answer to both of those injuries are a few hours. It doesn't mean that medically, if you time them, they will be exactly the same or that their time frames refer to each other. It's just knowing the mechanisms of subdurals causing death as well as pelvic fractures. It happens that they both would cause death around the same time period.
Well, thank you. I think I understand that. And I guess that's what I'm trying to understand is, you know, based on the loss of blood, or the lack of this kind of accountability says, the fact that there wasn't a requisite loss of blood related to the pelvic injury, that would not be the cause of death.
No, it would have been.
No, I apologize. Because I asked would be, I didn't ask would have been, could have been, might have. That's a whole different thing. It's a direct question. I'm not a doctor. I don't know, but it's common sense. Then it costs.
This is argumentative.
I'm.
Are you talking to me or are you talking to the witness?
I was talking to you. I'm talking to you because I asked you to instruct the witness to answer the question. I understand your statement before that perhaps the question, the answer would be more detailed.
Let me try this way, because I think I understand what you're saying. I think I understand what the doctor was saying.
It was very helpful. I appreciate that.
Okay, let's see if I can try. So you said the injury to the pelvic, in this instance, by itself, because enough blood did not enter the abdomen alone, that's absent the head injuries. He didn't die from that alone.
Well, no, that's what.
Let me try it another
Yeah,
way.
that injury would have resulted in his death alone if that was the.
If more time elapsed.
Yes, but
Because
he-
more blood would have gone into the abdomen, but that didn't happen because
Correct.
he also had the head injury.
Yes.
Which also by itself would not have caused him to die either. Not by itself in this instance, but the combination of them both.
But the head injuries and the pelvic injuries were severe enough that if they progressed to their natural end, would have caused death by themselves. In this case, they just because they were happening together brought about death sooner than they would have individually. But
So the
certainly
combination of them both is what caused his death.
Yes.
I really don't, but I'm gonna move on, Judge. I'm almost finishing with it. That's all the questions I have. Thank you very much. Thank you.
You redirect?
Doctor, given the amount of the injuries that you saw on his body, Would you even be able to say which of them could be self-inflicted?
If you pulled up a picture of a random one on his arm or his leg, abrasion or bruise, but there's no way to looking at the totality of these injuries and then telling you which ones the child could have done himself and which ones were done by other people. It'd be impossible.
And just so I'm understanding this, as it relates to the head injuries and the pelvis injuries, those alone, either of those would have taken him longer to die.
Yes.
But because they're occurring at the same time, he's losing blood from multiple places.
Yes.
And it's that blood loss together, which is what causes that.
Yes.
Anything else? No, Your
No.
Honor. Doctor, you mentioned that there was a subdural hemorrhage to the head, is that right?
Yes.
And brain swelling?
Yes.
With injuries like that, how long would it take for that person to die?
That would be, again, be several hours. I don't know when, at what point we would have lost consciousness in that, but usually if the subdural is you're bleeding more and more into it, it would take several hours to the point where it would cause brain herniation.
What, in your opinion, can cause this subdural hemorrhage? Is that blood force trauma?
Yes, yes, blood force impacts with either objects or fists would be enough force to cause that.
Would you sustain those kind of injuries while unconscious?
If you still have a beating heart, you still, if your unconscious body was being punched out the head, yes.
You said that you determined the cause of death to be blunt force trauma.
Yes.
You said he had a fractured rib as well?
Yes, the right posterior trunk.
Were you able to tell how long that rib had been fractured?
No, other than it was just a fresh fracture. There was no evidence of
Fresh
so,
fracture.
yes, so we would have occurred in the beating.
About the pelvis being obliterated, the matter that you said.
Oh, yeah, it was split open or split into. That would have been an injury that would have happened within 2 hours of his death. Because he would not have been able to walk alone with just that injury. He would have gone into shock and died. So that's not an injury that you can survive.
And the burns that you said, they were on his lips and inside of his nose?
The circumference of the right nostril, focally on the left nostril, going into his mouth, and then behind the left ear. All of those were burns done while the child was alive.
When you say burns, we're talking about heat burns from heat?
Yes, it could have been a lighter, it could have been a cigarette, a cigar, any sort of cylindrical object producing heat could have caused all of those injuries.
You also talked about some post-mortem injuries. And you mentioned something about his anus.
Yes.
Can you tell me a little more about the injury to the anus?
Yes, it was done after he had died. There was no evidence that it was done in life, and there were no other injuries. So
what was the injury?
It was a laceration or a small tear at the 6 o'clock position.
Was there any evidence of a sexual assault?
No, no.
Any questions based on my questions?
No signs of sexual assault. Do you perform a sexual assault kit?
Yes.
To your knowledge, send it to the police?
Yes.
Thank you, Doctor. Appreciate it. Any other witnesses I have with people? Any witnesses on behalf of the defendant?
Not the defendant.
No.
People?
Have 4 screenshots from the already video. I'm just marking them for reference, people's 14 through 17. I don't believe that's any objection to them.
Not
No, Mr. Counsel, objection, preliminary exam purposes, Judge.
Admitted?
Thank you. And you're gonna publish the audit report.
Yes.
At this time, the people would move to bind over on the charges of the complaint warrant. The charges that we're looking here are as the same as to both defendants. I'm arguing them together. I think that makes the most sense. I want to first start off with a timeline. Based on the testimony, you know, that back sometime in October of 2022, that there was Deshaun had a black eye. You know, that this caused him to live with his aunt and his grandma after a visit to his father. And we know that based on testimony that from Crystal Holloman, that she asked Deshaun about the black eye. She talked to his father about it. They came up with a plan. Before Deshaun was at his father's, he was with Alicia. Defendant number one. Defendant number one denied anything to do with his eye or that Avion had anything to do with it at all. We then fast forward to June of 2023, where Deshaun goes to live with his father for the summer. And then on August 16th of 2023, Deshaun goes back to live with his maternal grandmother. We know that at the end of September 23, beginning of October of 2023, his maternal grandmother sees Deshaun and brings him to school. We then have at the beginning of October of 2023, number one, Alicia and Deshaun moved in 3789 Pearl Hut, Navy. Number 2. That brings us to October 21st, 2023. Your Honor has heard all the testimony. Your Honor has watched both defendants' statements. We know from Avion that they didn't leave the house at all that day. Neither did Deshaun. You know from Avion's statement that he was downstairs most of the day playing video games. That he came up around 5 or 6 p.m. to play games. Other family members. No relation, not upstairs. We then have People's Exhibit 1A, 8:36 p.m. Where you hear Avion beating Deshaun, telling him to hurry up and go tell her. Hurry up and go tell her why you're not listening. His voice was identified by Angelina Bennett on the stand. At 8:37 p.m., People's Exhibit 1B, continuation of that beating in 1A. 10:45 p.m., we have People's Exhibit 1C. Deshaun moaning, Avion carrying him down the stairs. You see the mark on his arm, shot gladly just testified. At 10:47 p.m., just a few minutes later, in 1D, the police are coming upstairs. You kind of hear something in the background, some sort of moaning. Continuation of that at 10:48 p.m. in 1E. We hear that same running. You can see Alicia going back downstairs, carrying the cup. That's a screenshot of People's 14. You can also hear something in the background during that video. We then fast forward to 11:21 p.m. Equals exhibit 1F. The police are coming back upstairs. You can hear her filling something up with water. Continuation of that at 1:22 p.m. in 1G. See Alicia going back downstairs, carrying something a little larger than a cup, potentially a bowl. Looks like she's using 2 hands for it. Screenshot of that and keep the stick. Then we have at 11:23 p.m., just a minute later, 1H. People are coming back upstairs. And then again at 11:23 p.m. in 1I, going back downstairs. It's hard to tell if she's holding something, but there may be something in her right hand. Screenshot of that in people 16. And then at 11:48 p.m. in 1J, we have Alicia coming upstairs. It's like she's carrying or dragging something in her left hand. Then you're screaming and knocking. Screenshot of that. People 17. We then have 11:50 p.m. Exhibit 1K. You can see a figure of someone look down saying, "Oh God." You then see Alicia coming back upstairs from presumably the basement. At 11:56 p.m. in 1L, Alicia coming back upstairs when EMS arrives. And at 11:57 p.m., the EMS has arrived and they're helping the victim, Sean. We know that the fatal injuries in this case, as just Dr. Levy has just testified, could not have occurred more than a few hours before death. At most 4, somewhere between 1 and 4. We also have a post-mortem injuries, Judge. I submit to you based on the evidence that Deshaun was already deceased when he was brought upstairs, based on the post-mortem injuries, and we have testimony from his Kenneth. He was pulled to the top already. I want to talk about their intent. When we talk about their intent, that goes to first degree felony murder, it goes to first degree child abuse, and it goes to torture. Their intent can be proved by what they did, what they said, how they did it, weapons used, and also show intent. Here we have a lot of self-serving statements, Judge. Let out lies. I submit to you they're false exculpatory statements. False exculpatory statements are evidence. When there's evidence shown the statements can be false, and they can be used as circumstantial evidence of guilt. Let's look to Alicia's statement. Basically, the whole thing is lies. First lie. Grandma dropped him off. Second lie. Recently, they wanted him, and I let him go over to his dad's. Third. Noticed wounds today when he came back. 4. Victim was walking and functioning. 6. Had to play with the baby. 6. He was good for a couple hours and then sore. 7. He was walking past and then fainted. 8. ABM left around 8 p.m. 9. He was with his dad and his grandma last week. 10. Grandma picked him up from school Thursday and Friday. 11. That she used Vaseline. How do we know these are lies?
What was 11? I'm sorry.
Oh, that she used Vaseline.
Oh.
Those are just ones that I can
You
count.
forgot 12 that she washed his feet.
Yes, 12, Judge.
I'm sorry, I didn't hear the court.
That she
She
washed her
forgot
feet.
12 that she washed his feet.
Yeah.
Oh, thank you.
These are not all inclusive, Judge. I'm sure I missed some. I'm sure there's more. But how do we know they're lies? Well, everything everyone else in this courtroom testified to. And the video. We heard from Miss Bennett. We heard from Mr. Tucker. We heard from Miss Johnson Bolton. We heard from Miss Crystal Hall. Whole statement. That's how we know that these are lies. Specifically, in the photos, his skin is not greasy either. That's leaving us greasy. Skin not be dirty. Next, we can look at Avion's statement. The lies that we have there. not all inclusive, I'm sure I missed some. One, he came from his dad who parked 2 weeks ago. Avion said he left the house around 9 or 10 p.m. that night. Third, wasn't down there when it happened. Fourth, and I quote, if I know that I didn't whoop somebody, so that's direct in conflict with video in which you hear him whooping Sean. Fifth, maybe, no, this, I don't discipline. I would argue that this goes more than discipline. Six, standing and unequal. All of these things are lies. They're inconsistent with every other piece of testimony. Could not have been walking or functioning with the pelvis fracture. He couldn't have been standing and then collapsed. You know that from Dr. Levin's testimony. To Dr. Levin's testimony. 225 abrasions alone. 225 whips of an arm, whacks, kicks, hits. His pelvis was completely broken in half. And the amount of force that it takes to do that is incomprehensible, Judge. Dr. Levin says it's not common in children, it's hard to break their bones. What can cause it? A horrific car crash, a fall from more than 2 stories, not things we have in this case. In fact, we can also look at the burns in his nostrils. I'm not saying that the lighter that we have in the video is what caused that, but it's consistent with it. It could have. I don't know if it did or didn't, but it's the evidence that we have. We can also look at the objects found and used. Talk about that metal hanger, the white metal pieces, and the belt. This is not an issue of who did it, Judge. We know they did it. Avion is on video doing it. His voice was identified. Hurry up and go tell her why you're not listening. We know Alicia did it. We know, and she knew it was happening too. She's on video, coming up and down the stairs in the time frame. We know she's downstairs too. We also know that she may have a history of it. That's given her knowing about the black eye. We also know, I believe in the photos from the search warrant at the house, I didn't see any sink in the basement. She had to go get the water from upstairs. Specific to child abuse first degree, both of the defendants had care, custody, and control of Deshaun. They lived together in the basement, only them in the basement, moved in together specifically. And specifically to torture's fourth element, I've already addressed the gang intent. Torture, you have to have that it was intended to cause, suffer, cruel, or extreme physical pain, mental pain, or suffering. 225 abrasions. That's 225 times at least that they made a conscious and intentional choice. We know it wasn't deep bruising, and that the skin has the most feeling. These injuries were intended to inflict pain. For the reason would someone have to cause these kinds of injuries and amounts of injuries? Did not. As we know that these two did it together. It's not just one or the other. Alicia has knowledge. They're down in the basement together. They have a close association. The boyfriend and girlfriend, they live together. We even see flight. Maybe online. They're working together. We know that they don't have to share the same intent. It's enough to be acting to aid and abet with the knowledge of that which the principal intent is sufficient. However, I would argue that Alicia knew the natural and probable consequences of feeding Sean and supplying hot water. She still knows that. We know that any words or deeds of the defendants which may support, encourage, or entice commission of crime in concert with the principal are sufficient constitute aiding and abetting. For people Palmer, 392 Mish 370, it's 1974 case. Here, specifically at school, usually we have getting the water back and forth upstairs on these videos. We know Dr. Lavia was burned on his legs, assisted with hot water. Aiding and abetting describes all forms of assistance, rendered, and comprehends all words or deeds, which use support, encourage, or entice. Sean was cold when he was brought upstairs.
I didn't hear that.
Sean was cold when he was brought upstairs. He has post-mortem injuries. How long were they down there planning, watching him die, cleaning? We know that scene was clean based on the evidence center. And shower having to use blue stuff. There's enough circumstantial evidence here that Alicia Allman knew she was more than just there when she was bringing cups of water, buckets of water, maybe a bowl, downstairs at least 2 times, which is the people's position that caused burns, aiding and committing, probably using the first degree and torture. Then we also have the prior evidence of the prior assault. Also argued, all I knew. Maybe I'm saying in that video, hurry up and go tell her. Hurry up and go tell her why you're not listening. Her. I would refer to the mother. Alicia Allman. They're in it together, Judge. Of reasons. And more. Court request. Court find over on the charges of the conflicting warrant. And I'd be happy to address anything further in the rebuttal. May I?
Yes.
Well, as is uncharacteristic of me, I'm going to try to be brief. I would suggest the court, first of all, very first thing that I think is very important, and I'm not being facetious about this, is you have to identify acts perpetrated by an individual individually. You can't just say they, you can't say they did, because particularly this is because there's no, if my understanding is correct, my understanding is from reading prior preliminary exam transcript, direct testimony about what happened in the basement in terms of testimony in this preliminary examination. There's no evidence of anything that Ms. Howard did directly, if I'm not mistaken. I may be this. Secondly, and I'm saying so that the prosecutor has to say Ms. Howard did X, Y, Z. Even if it's in terms of, if you want to say aiding and abetting, you have to show how this person aided. Not like we can guess. This is not a thing of, this is a probable cause hearing, not a possible cause hearing. So we can't say this could be the reason, that could be the reason. It has to be, this is what we know. And you don't know on a probable cause basis about that. Then the other thing, I'm going to specifically refer to the torture charge. It's very interesting that people impute knowledge to other people. We have a doctor who says, I didn't know, it's news to me right here today, not that I'm smart or anything, that the skin is the most sensitive of all, most susceptible to transferring pain, transmitting pain to brain receptors or whatever. She says words. That's the idea that I got. So the suggestion is that because a doctor says something, that Ms. Howland would know, just for purposes of the discussion, Ms. Howland would know that's what the case is. I don't think that's the case. So in terms of torture, torture has to be something that you know. And that's not anything you can attribute to an ordinary person No, that's not to say you can't say that certain things might be painful.
You have seen this exhibit.
I have seen it. I have, but that's a different thing. You see, this is what the point is. You're making an argument based upon a medical conclusion of a medical statement of a doctor who went to school for 8 years, 12 years.
I didn't make it. All I did was look at the pictures and I could tell this baby is tortured.
Well, that's, if you've already made a conclusion, then there's no point in you going on any further, because you made a conclusion without my argument or without the full counsel.
What do they say about pictures?
Pardon me?
What do they say about pictures?
Well,
something about them being worth 1,000 words or something like that.
Yeah, but then you have to say what words are there? And that's the point I'm making. The words that we do have from the prosecutor and the medical examiner suggest that a person imputes knowledge to a person who's not of the same training, experience, understanding as the doctor. So the doctor, that's a different thing. I understand what you're saying, and I think this is the reasonable.
The allegations are that this baby was burned, hot water, burned the lips with some kind of flame in the nostrils and behind the ear.
I understand. I understand.
Again, that sounds like torture to me.
And then the prosecutor, I'm sure, let the court know who did it. And that's very important here, because I haven't heard anything that said Ms. Holland burned the baby behind the ear, on the lips, that I haven't heard anything like that. And I didn't read anything like that in the transcript of press. You did. I don't know. But I don't think you did. Because I don't think you did, and because I let you know what this is a probable cause here, where they have to present evidence on the elements as to each individual defendant, I'm suggesting the court, not suggesting, I'm objecting to the bind over and asking to dismiss the case. Thank you, Lord. Thank you.
May I please support? Judge, first and foremost, it's difficult not to look at what has been presented by the prosecution as it relates to torture or anything else. I'm not going to make an argument against that. Undeniably, I think what is present here today is the prosecution made an argument as it relates to the guardianship, the parental rights, all of these different things associated with this young man. The question presented is, my client has none of those things, Judge, none. What we have here at best is a relationship of sorts, that they're residing together in a basement. It is undeniable that the number of scars, 200 plus abrasion scars, whatever have you on this body, is consistent with a history of abuse. But that does not link my client. What we have here at best, Judge, as it relates to Mr. Traylor, is there's a video, limited. In that video, Sister Counsel indicates you hear not one, but there's two men. There's also Lovejoy that's present in there. And what you hear is, hurry up and go tell her why you're not listening. And you hear some sounds, but there's nothing within there that says that my client is talking. But there's also Mr. Lovejoy that.
I thought we had a witness who identified that as your client's voice was the same.
Exactly, Judge. But there's also Mr. Lovejoy who was present during that period of time. So what we have, Judge, is if this court is to draw that conclusion, we have one particular incident that you hear for a short period of time. You have what Sister Counsel said, and I find it somewhat interesting. It's true that there are inconsistent or perhaps lies that are said in these particular statements that are taken by the defendants, right? So if this court is to extrapolate that is some type of conclusion of guilt, then I would suggest to this court that they're inconsistent statements. They are lies. That means this court can't take any of it to be true, period. And that, the prosecution indicates, relates to purportedly Mr. Traylor as well.
You know, that jury instruction says that jury can choose to believe all, part, or none of any witnesses.
I understand that, Judge, but the position of Mr. Traylor is unique than that of his mother. And while we're a co-defendant, certainly I make no admissions or suggestions as it relates to the mom in this particular instance here. As it relates to Mr. Traylor, is a very unique situation. Mr. Traylor is not the father. There's testimony that is offered to this court from the paternal grandmother and the maternal grandmother in terms of care. None of those are related to Mr. Traylor. None. He's not the dad. We don't know the extent or the involvement of this young man and the discipline of this child, if you take any issues or if you take any of his statements as it relates to the child, he's not in a disciplinary role. He is not. Anything that's related to any testimony is within the home, there's multiple people when this particular incident happens. And the testimony is that this is a small house. You have people on top, which is the uniform area in the kitchen or the light, and then you have other people in the basement. And if there is torture that's taking place there, Judge, then it's a small home with a limited amount of area. They would hear that. That's not what the testimony's been elicited. This court has the duty as it relates to probable cause. Was a crime committed and did an individual commit a crime? Looking at these photos, looking at the nature of the injuries, I think that this court has extrapolated as it relates to what happened. But who did it is the question that's presented here, Judge. And I would present to this honorable court that there has been a tenuous, a very weak position as it relates to Mr. Traylor, period. Mr. Traylor was present, sure. Mr. Traylor is seen in a limited capacity, sure. There's an identification of a limited voice that shows for just a few seconds, sure. Does that rise to the level of homicide, felony murder? Does that rise to the level of child abuse in the first degree? And does that rise to the level of torture? And I would submit to this court that the evidence presented does not rise to that level as it relates to Mr. Traylor.
Yeah, more this one.
Just briefly, Judge.
Sorry.
As to Mr. Brown's argument, direct evidence, Judge, would it be great to have that? I mean, I guess we have a little bit with the video, but we don't need direct evidence. We have circumstantial evidence, which is just as good as direct evidence. Beyond that, Mr. Brown says we have nothing that shows beyond someone going up and getting water, beyond statement with machine level lies. And he talks about knowledge. That Yemi can't impute knowledge. She doesn't know that the skin, contains nerves. Why would she know that? I don't know, Judge. Because she heard, I'm sure that she heard moaning and crying since he heard about the video. She was downstairs with him. That would tell to anyone who's listening that that child is in pain and suffering. And as to Mr. Max's argument, he doesn't have to be the father. He just has to have care, custody, or control. Meeting the child on the stairs, I think shows control over him. It shows that he was in a position to perform those acts. Had control over that child. He's carrying him from upstairs to downstairs. It says in the statement he bathes the child, usually every day. I don't think that's an issue. There's any issues here at all. Thank you.
You find it all? No. Okay. So both defendants are charged with felony murder, child abuse, first degree, and torture. This may take. As it relates to the torture, there's no question in my mind as I look at the people's exhibits and the testimony from the Wayne County Medical Examiner, Dr. Lavity, that this child was tortured. As I looked at the exhibits, before I even heard from the testimony of this Dr. Lavity, this baby had what appeared to the court to look like puncture wounds, burns, bruises, and abrasions all over his body from head to toe, literally from head to toe. Few things just didn't make sense to me before I heard from Dr. Lavity. I didn't understand why I was presented with this video of defendant Howland coming upstairs and going in the kitchen and I keep hearing this water running. Didn't make sense to me until I find out that the baby had these burns on his legs consistent with being burned by essentially boiling water or something close to it. One of the exhibits that the court also observed was the defendant in the background while this child is moaning in agony, telling him, tell your mother this, that, or the other. Tell your mother this, that, or the other. The other thing that strikes me is during their interviews, which the court had an opportunity to review in camera, is both defendants trying to distance themselves physically and emotionally from this child. This is Miss Holloman's baby. And although she cried during the interview and the breaks during the interview, she sat there emotionless today. And knowing what was done to this child and seeing this child, that she saw it up close and personal, she didn't have to look at it in pictures. She saw it in 3D as it was going on. How can a mother of a child sit there emotionless?
I'm sorry, I'm not disrespecting. I want to tell you that I went in the back and I told her I didn't want any outbursts. I didn't want her crying. I just said, just hang on and listen. So I want to tell the court that in all fairness, because that's my instruction. I went back there and told her, did I tell you that? That's what, so I want the court not to take into consideration her demeanor today based upon what I instructed her to do.
All right, well, say that.
Okay, thank you.
Okay. This, and I've been doing these homicide cases since 1998. Sometimes I kind of worry about myself because sometimes I feel like I've gotten sensitized to this stuff. Until you run across a case like this, and I've had cases of mothers putting their babies in the freezer. I had cases of other abuse that children had died. I have never seen a child beaten or battered in the manner in which this child was beaten and battered. And Dr. Landry tells me that these are relatively recent injuries to this child, as well as post-mortem injuries. Post-mortem, given the fact that I see both defendants with this child at different times, that it's impossible for this child to have been able to stand, let alone walk. Again, I see images of defendant Trailer carrying the child. I hear defendant Trailer fussing at the child. I see defendant Holloman bringing the child upstairs after presumably he's dead already. And they're trying to revive him when EMS arrives at the scene. I see her going back and forth up downstairs for water. She's running water in the sink. It makes sense to me then, but it makes perfect sense to me now. Then I hear that there's evidence recovered from that basement consistent with what this child may have been beaten with. So there's no question that this child was abused, that this child was tortured, and that he died as a result of that abuse and torture. So the charges are here: the felony murder, first-degree child abuse, and the torture. The only question, if there is a question, is to who we attribute that to. Do we attribute that to Mrs. Holloman? Do we attribute that to Mr. Trailer? Or do we attribute it to both on an aiding and abetting theory? And because there's no cameras in that basement to see who does what, people have presented a very circumstantial case. Circumstantial evidence doesn't mean that it's bad evidence. In fact, there are certain circumstances in which circumstantial evidence is more persuasive than direct evidence. And I submit to you that that's exactly what we have here. Because of the lies that have been told, because of them trying to distance themselves emotionally and physically, we have Mr. Trailer saying, well, I'm letting his stepdad, I just take care of him. But they tell me how much they love him. Both defendants presumably love this child. There's no way that this child's pelvic could be obliterated in the manner in which it was. Medical examiner says the amount of force that it would take would be more than it would take to do to an adult. This was a child, a 7-year-old child, a baby. Why? Literally beaten from head to toe, from the top of his head to the toe on his right foot. Beaten, burned, bruised, fractured ribs. I don't think that there has ever been a more blatant case of child abuse that I've ever seen. Short of Star, I've seen that too. This ranks right up there. So I don't worry about myself so much anymore after seeing this case because I do have some feeling left in me. Maybe not showing it right now. This is absolutely reprehensible. This is demonic. That anyone could do this to a child. That anyone could stand by and let this be done to a child. Setting emotion aside, have the people met their burden? I submit to you, I believe they have, based on the lies that were told by both defendants, based on the video evidence of what each defendant was doing. Ms. Holloman going up and down the stairs getting water, and then we have evidence that the child was burned on the leg with hot water. Mr. Trailer in the background yelling at the child about, tell your mother why you won't listen. Some words to that effect. The post-mortem injuries to this child. We know that there was no one else with the child but Ms. Holloman and Mr. Trailer during that period of time. I think you have a circumstantial case, but you have a strong circumstantial case. As such, the court is satisfied that people have met their burden. People have met their burden of probable cause as it relates to the charges pertaining to the complaint warrant. The court finds those charges were committed in the city of Detroit. The court finds probable cause to believe these defendants committed. Both defendants will be bound over to Wayne County Third Circuit Court Criminal Division for proceedings. Their arraignment on the information date and time will be December 14th, 2023 at 9:00 a.m. Both defendants will be remanded to the custody of the Wayne County Sheriff.
Thank you. Thank you, Judge.
It's not one of your friends over there, Judge. I was just came from Frank Murphy. Who was that? The Honorable Bradley Cobb. You know, because he's you know, I have a thing because both our fathers. Oh yeah, you know. But he went that way. I went that way.
Thank you.
Hey, can I give them, did they come up with something too? Can I give them some papers? Please, I'll give it to you right now.
Anyway, want to have a good afternoon.
Okay, you too.
Pleasure is always mine.
Let's turn it on.
Right on there.
get a bunch of witnesses in the room.
Yeah, I'll go get it. Thanks.
Okay.
The only thing I don't have is your flash drive.
Okay.
I'll bring it tomorrow if you're around.
All right.
Monday, I think.
Okay.
Good Monday.
I'll still bring it tomorrow.
Okay.
Yeah, that's right. All the way over here.
Turn off the jumps. The microphone. Okay.
I know how to make a red light go on.
You okay? Well, that's what I'm talking about. Make it go on.
Well, that concludes the docket for today, folks. Hope to see you tomorrow, same bat station, same bat time. Have a good day. Yes. Me too. Right when I thought I was getting sensitized to this stuff, I realized I do still have some feelings.
You mean to tell me, your attorney tell you not to show any emotion, you just gonna not show them?
Yeah.
And I was sad.
You could just get into the daddy or the grandma.
But see, her allegiance is to the guy because they were sleeping in abandoned homes at the time. So she came to save him. She don't care about him. She gave him to his dad and his people. She came about faith.
Why did you just get to tell them? You don't want to tell us.
All right, so that would go.
All right.
Yeah.
What did they do in this way?
Exactly.
This kind of social assault.
She's gonna do it.
Because even if he didn't do anything, he still watched it. He was
Well, he knew what was going on. He participated. He's just as guilty as standing there when somebody's out of the door. Just as guilty. You should have reported her to the child and use that.
Exactly. Immediately.
You want to deal with the cross for exact. No mistakes. None. None. Is there anything you want me to do for you? Everything. I got your mail. You said, well, you take your mail.
I don't have any mail, what I'm melon. Everything I'm doing right now, I have to. This requires that you. I appreciate you.